Well, hey everybody. I made it through day 8. Another day in the bag in the trial of the state of Indiana versus Richard Allen over here in Delphi. Today was a little bit more of the same. We built on some of the stuff that we've already heard, filled in some themes. So, our big picture breakdown for today, we heard from another eyewitness and we got yet another inconsistent description of Bridge Guy. We heard from the forensic pathologist today, and as well as the Idaho State Police officer who conducted a more extensive evaluation of the cell phone extractions from Liberty German's cell phone. And with both of these witnesses, they cleared up quite a few questions, but then they also raised quite a few others. So, on balance, still left us with some confusion to resolve. And then the big news of the day for me, Judge Gold denied my motion. I admit I am surprised that she even bothered to deal with it, but she did. So I will be evaluating the next steps in the coming days. Well, let's get right into the details, guys. Let me start by the way that my morning started today. I was blessed by an angel from heaven. I was there at the courthouse steps at 2:30. I made it there, and I was walking up the little ramp that we all hang out on with my chair and my blanket and my big heavy down quilt and everything. And a woman greeted me on the ramp and introduced herself as my line sitter. Ha! Hallelujah. I'm not going to dox her, like, out her publicly or anything like that. But she was absolutely just a perfect blessing at exactly the right time. And so because of that, I was able to go back to my car and get a few hours of extra sleep in my car. And I can't tell you what a difference it made. You wouldn't think that the difference between 3 hours of sleep at night and 6 hours of sleep would be monumental, but it absolutely was. It just kept me going through the day so much better. So thank you so much. Those of you who are helping to organize line sitting, there's a group of folks on Reddit that got together and just kind of took this initiative. I'm so thankful, really grateful for the help. You guys are amazing. I'm kind of a little bit overwhelmed that people are volunteering to do that on their own accord. So that helped me a lot with getting through the day, and as a result, I do have quite a few notes to get through. Although I'll just do my notepad count a little bit early today. I only made it maybe a little bit more than halfway through one legal pad, maybe about you can't really see that very well. Maybe about 2/3 of the way through one legal pad, so not quite as much as the last couple days have been. In part, that's because so much of the testimony was during the forensic pathologist's examination, and so we dealt with a lot of photographs and not so much oral testimony to be taken down, but taking in a lot of visual information. But I do want to back up and start at the beginning. So start at the very beginning. Those of you on the Bradley Rossi style watch, today he was in a navy blue suit. It had a light gray or light blue, like square check pattern, and a lovely mustard colored, kind of gold colored, somewhere in between those two, tie over a white shirt. It was quite striking. We started today with Sarah Carbaugh. She was our first witness of the morning. When she came into the courtroom, the very first thing that I noticed is she had absolutely beautiful hair. Beautiful long strawberry hair down to her waist, strawberry blonde hair down to her waist, just a small barrette kind of holding it, like here, a little bit out of her eyes. It was absolutely glorious. I could have looked at that hair all day. So Sarah Carbaugh was one of the eyewitnesses to Bridge Guy. She's the one who Mr. Baldwin described in his opening statement as the bookend to Betsy Blair. Betsy Blair would have seen Mr. Allen before, or Mr. Allen, you know, if assuming Mr. Allen is Bridge Guy, she would have seen the Bridge Guy before the time of the murders and the abduction. And then Sarah Carbaugh would have seen him after those events took place. So her testimony went as follows. She is a Delphi resident, describes herself as local as you can get. She lives close to the Monon High Bridge Trail. She's familiar with it and visited it daily or nearly daily during this time because she has dogs and it was a good place to walk. She would also often pass the trail entrance, that Mears entrance that we've talked about on the road. So she always used the Mears entrance when she would visit the trails. She was not one, she described herself as like not one who was big for crossing the bridge. She did do it a few times when she was 16. She chickened out the last time that she did it, and as an adult is not inclined to cross the railroad bridge. She was on direct, a very open and somewhat enthusiastic witness. She seemed to have been prepped, and I say this because she would deliver her answers to the jury. So the orientation of the courtroom, the witness to face the attorney is typically either they tend to leave their tables and move around a little bit. They stand at different points in the courtroom, but typically in the middle-ish of the courtroom. And so to face the attorney, the witness would be facing this one direction, and then the jury box is in the opposite direction. So Ms. Carbaugh was turning to listen to the prosecuting attorney with a question, and then deliberately turning to address her answer to the question, direct her answer to the jury. So this is a technique that a lot of law enforcement officers do. They're kind of trained to do that. People have kind of mixed opinions about its effectiveness or whether it's a good idea, particularly with lay witnesses, because it does sometimes come across as a bit unnatural. The jury is certainly the audience for your testimony, but the communication is going on with the prosecuting attorney. And so for most people, it's just your normal conversation. You would be talking with the person who's asking you the question. And so that's what typically seems natural for a witness, is to address the attorney who is questioning. So she did have that mannerism, I guess, that did tend to suggest to me that she has probably been prepped for her testimony. She did not know Abby or Libby. She had learned that they were missing the same day that they had gone missing. She got an Amber Alert and was aware of it that way. So she was in the area of the trail that day, but she did not go out on the trail. What she described is that she was driving by in her car to try to scope out how busy the trail was by just seeing how many people were parked in the parking lot. So she didn't go into detail. I'm assuming she was just sort of going about her business that day, but she would pass the trail periodically and check to see how busy it was in the parking lot. So she said she passed by it 3 or 4 times. It was a beautiful day, and she was driving around. And every time she went by, there were vehicles there. So the last time she went by, she indicated it was about 4 o'clock, and she saw a group of people at the entrance, including a girl with bright blonde hair and a hot pink t-shirt, a hot pink shirt. They were kind of talking in a group and seemed very stressed. And at this point in time, she was heading east on that 300 North Road that we've heard about that goes back towards her home. So she continued on past the trailhead and saw a man a little bit further up who she described as being covered in mud and blood walking on the side of the road. So he was on the north side of the road walking back towards Main Street, so it would be westbound on 300 North, and she was then on the other lane, the opposite lane, going eastbound. So he was on the driver's side, meaning like she didn't have to, look through her passenger window to see him or anything like that. He was right there in her line of sight as she was driving by. She describes that she looked at him and he didn't make eye contact with her. She indicated she had been driving about 30 or 35 miles an hour, but slowed down slightly when she saw him just to go past. She didn't recognize him. She did not know Abby and Libby were missing at this point in time, so nothing, she wasn't like on the lookout or anything like that. She designated all of these areas on a map that has been introduced as an exhibit. So then it was when she got home that she learned that Abby and Libby were missing. Later on, she saw a photo of the bridge guy on the news and indicated that she had another one of these recognitions. She recognized it instantly as the man that she had seen walking covered in mud and blood on the road. So her description of him was that he was covered in mud and blood. His demeanor was way off, and she offers to demonstrate this. I took this as an indication that she was kind of an eager witness, like she was eager to show the jury what she knew. She wanted to demonstrate what she meant by his demeanor while he was walking. Like she didn't have the words to describe it, so she was eager to kind of get out of her chair and do that demonstration. The prosecutor, Stacey Diener, was handling this questioning, actually stopped her and paused her, said, wait a minute, we'll get to that. She said that his demeanor was sketchy, that he didn't look at her, his head was down, and she said that his pants were covered in mud. The part below his knees were covered in blood and blood splatters. She said she thought he had fallen down off the cliff or something like that, like fallen onto the rocks. She just I think was trying to maybe mentally explain to herself what she was seeing, and that was kind of her guess. Maybe he had fallen down the cliff and hurt himself. She put the time at about 4 to 4:30 because the sun was in the process of setting at that point in time, and so she had seen a kind of orange hue in the sky behind him when she passed him. So she did contact police about 3 weeks later. She was questioned about why the delay. Why did she wait to contact police? And her explanation was that she had been very traumatized by this murder. She is a big overthinker, and that basically not acting was a combination of her both being upset and being, I think, a little unsure about herself, about, just her role in it. Stepping forward, is that, is it appropriate? Does she have the type of information that's worth bringing forward? Ultimately, about 3 weeks later, there was an officer at the Mears entrance. They had set up a blockade, and apparently at several parts around the trails, they had set up blockades. They were stopping people that were coming by and asking them for tips. They were looking for tips. So she decided at that time that it was time for her to be brave and tell somebody what she had seen. She was familiar with the Hoosier Harvest Store, knew where it was. She said she didn't actually know there was a store back there, but she knew the general vicinity. And so the police had shown her the still shots from the camera of what they believed to be her car. And so she was able to identify it as her car based on the timestamp of that video. The time put it at 3:56 p.m. And so that tended to corroborate her timeline of when she says she saw this man. That was pretty much all that she had on direct examination. So Mr. Baldwin handled the cross, and Mr. Mr. Baldwin, he's not an aggressive, he's not a mean lawyer. None of them really are, but just in terms of being a little bit more in your face, the most in your face of all of them is Mr. Rosie, by far. He will smack you with the facts that he's using for his confrontation. Mr. Baldwin is much more. He handles them with kid gloves much more. Like he will get the information out, but he seems to try to be fairly gentle about it. But that said, fairly instantly, we saw a demeanor shift from Ms. Carbaugh when we went to cross-examination. She began to get defensive pretty much right off the bat. So the first thing that Mr. Baldwin asked was that in your first interview with police, you said mud 11 times, but you never said the word blood. Her answer was that she believed that she did say blood, but law enforcement didn't pick that up. It didn't get picked up in the interview. She said she described that she was nervous and that she mumbled and that she rambled, she said she recalled a point where she stood up in the interviews, and that's the point where she described the man as being covered in mud and blood. But according to Mr. Baldwin, the word blood does not appear anywhere in the transcript. So her memory of what she said seems to not be substantiated by the testimony or not testimony, it was a statement, but by the transcript of her statement that she gave to police. Then a couple weeks later, according to Mr. Baldwin, she gave another interview, and that time she used the word mud 13 times, but again, never said the word blood. On this occasion, she said that she thought that she did, and that there is an hour to an hour and a half portion of the interview that was missing, that is just gone. So it wasn't clear, is this part of the whole interviews getting lost issue that we've heard quite a bit about from the defense, as part of just some of the failings in this case by law enforcement, the failure to preserve those early day interviews. Really wasn't clear how or whether that was reflected in the transcript, if that was something that Mr. Baldwin knew. That we did not really get a crystal clear answer to that. The bottom line, according to Mr. Baldwin, is that in any event, the transcript at no point included the word blood. So Ms. Carbaugh she was contesting this. She was quite certain she had used the word blood. So Mr. Baldwin gave her the transcript. She sat there and she flipped through every page of that transcript. And the jury, I noticed, was watching quite attentively while she did that. They were watching her page through the transcript. Ultimately, she says she doesn't see the word in the transcript, but she does remember telling the officer and marking it on an image. So then there was a third interview that she gave that was approximately 2 years later, where in this one, she never, according to Mr. Baldwin, said the word muddy. She only described him as being bloody. She explained this by saying that at this point in time, it was 2 years later, and so the important details were just as simple. The simple point that she saw a bridge guy walking covered in mud and blood. Mr. Baldwin's like, but you never said mud the third time. She says, I believe I said mud and blood, and that her description has always been the same. So then, now again, Mr. Baldwin goes ahead and gives her the transcript of that interview to refresh her recollection. And she was flipping through the transcript. Again, jury is kind of watching this happening. She's flipping through the transcript and ultimately indicates no, she did not see the word mud in that transcript. So at this point, Mr. Baldwin asked her, I guess it's not true that your description has always been consistent, and she conceded, I guess not. She did not seem happy about making this concession. My impression when they were going through this kind of back and forth about did you say it during the interview, Mr. Baldwin's clearly taking the position she gave inconsistent statements. She is clearly believes that she gave consistent statements every time. It might just the impression that I had gotten was that she had anticipated that she was going to be challenged on this. It could have been through preparation. It's not uncommon or unethical. Some people think it's like unethical to talk to the witnesses before trial. No, it's not. It's perfectly common and perfectly normal to prepare them for what the process is going to look like and the types of questions they might anticipate being asked on cross-examination. So if Ms. Diener had sat down with her to prepare her for her testimony, she may have mentioned, you know, Mr. Baldwin's going to say, you know, you were inconsistent or whatever, either because it's reflected in the transcript or, you know, a bare minimum because Mr. Baldwin had said that in his opening statement. Mr. Baldwin then approached her with, apparently she had described the man as looking like a hog had been slaughtered, that's how much blood that she saw. She said she seemed kind of surprised at that description, like maybe she didn't remember giving that description. She said, I've never seen a hog slaughtered, so I don't know how accurate a description that would be. She was getting a little bit, her energy level was going up. She was getting a little bit combative. She was going a little bit from defensive to a little bit more, she was becoming angry. It became visible at this point, really notably, because she not shouted, you know, but raised her voice. I didn't think he was a murderer at the time. Or like, why would I think he was a murderer at the time? I had no reason to think he was a murderer at the time. It was something along those lines. Kind of seeming to be angry at Mr. Baldwin. And then Mr. Baldwin asked, well, did you stop to help him? You know, seeing a man all covered in blood on the road. At this point, she got quite angry. And she said, no, I didn't stop to help him. She's like, I didn't stop to help him. I'm a woman. I'm not going to stop and help some man. Mr. Baldwin then confronted her with, apparently in the first interview, she had described the coat as tan. Later, it became blue. She agreed that calling the coat tan was inaccurate. Her explanation for this was that the coat was always blue, but she said tan, and she thinks the reason why she said tan was just because he was so covered in blood. She said specifically, Mr. Baldwin was suggesting, well, you changed your story after you saw the photo of Bridge Guy. You know, basically, you got contaminated by the photo. This is certainly a theme the defense has raised with the other eyewitnesses. He's raising it again with her. She said that she specifically told the police she didn't want to be contaminated by the photo. She didn't want to be shown the photo. I believe it might have even been reflected in the transcript that she made that comment. But it was everywhere. She said it was everywhere all over town. It was very hard not to see it. It was posted, like it's still up apparently in some places. So, you know, Bridge Guy was pervasive. And according to Mr. Baldwin, despite her not wanting to see the photo of the Bridge Guy, the police officer during this interview put it on the table and left it in front of her for the entire interview. She didn't remember if that happened, so we didn't get specific confirmation of that. She was defensive. She did not like the suggestion that her description was not accurate or that her description had changed. She was very insistent. Her story has never changed. She was describing herself as being very anxious as a result of all of this. She didn't want anything to do with it. You know, she's basically here as a witness because she has to be, because she's under subpoena. In the second interview, according to Mr. Baldwin, she said that he was wearing a brown sweater and had a little curl to his hair. So she said that there might have been a little hair sticking out. It was a little hard to say whether it was curly or not, but just her recollection was that there was a little hair sticking out. Mr. Baldwin then said, during this interview, you said he had effeminate eyes. She seemed to be quite offended by this. Not quite clear to me why that would be, but she was very emphatic. No, I never said that. Mr. Baldwin asked, would it help to review the transcript to refresh your recollection? And she said, no, I'm good. He indicated, she seemed to have said in the interview that she didn't have her phone with her on the stand. She was kind of, dismissive of that. No, of course I had my phone. I would not have left. I don't feel like I would have left the house and drove all around and everything without my phone. And also, my phone pinged off of the tower. That's part of how they were able to contact me. And I know they went into the tower nearby and pulled off every person who pinged off of that tower. This was a question to me. Did she open the door to geofence data now? The geofence data has been excluded from court. Not for a particularly good reason, as far as I can tell. The reason is because it's unreliable, and the gist of why it's unreliable is because the tower coverage is essentially the entire town of Delphi. Geofence data is far more than tower data, so I'm not quite sure that I understand this rationale. Geofence data typically goes to a provider. Like if you're on an iPhone, it's going to go to Apple. If you're on an Android, it's going to go to Google. And what they do is they pull the location information, the location services information off of all the phones that have it enabled that they carry, and they're able to sort through all of that data for a particular geographic area and then provide to police. These are the cell users who can be placed, their location services on their phone, place them within this particular geographic area. So tower data can be a source of that, but GPS data is also, it's maybe even a bigger source for geofence data. So I really don't understand this ruling. It's another one that to me is quite highly problematic. But I wasn't at the evidentiary hearing where kind of all of this stuff was hashed out. So I don't have a lot of information about what, if any, details they had about Mr. Allen's location and whether the exclusion of geofence data information is likely to be considered harmless error on appeal or not. I think it's certainly an error, but it's not necessarily one that is going to get you a new trial if it's not something that is, relatively exculpatory. So that was an information that she had volunteered that instantly raised a flag for me. Boy, I think we may have opened the door to the geofence. By this point, the witness is quite hostile. She is very angry. She is not happy with Mr. Baldwin at all. He wanted to kind of pin down exactly her ability to make the observation of the man that she described. So they nailed down the speed. She said she was going about 35 miles an hour. She wasn't looking at the gauge, but obviously she wasn't speeding. And she said she saw him for about 30 seconds, which seems like quite a long time for driving on a road and passing somebody. I don't think that's, probably, just my opinion, probably a very reliable estimate. I mean, that would be 30 seconds is a long time, and she's driving at 35 miles an hour that you would be creeping past, and that's just not consistent with what she described. She described the man as in his 30s, 40s, or 50s. She said he caught her attention because he was suspicious. He was wearing extreme layers for the day, for the conditions of the day, which is consistent with the descriptions we heard from the other witnesses about Bridge Guy as well. And just by being very weird. So Mr. Baldwin pushed back on this 30 seconds to see him, you know, this opportunity to see him for 30 seconds, because in her deposition she had said a mere instant, and she said that's yeah, that's 30 seconds to her would be consistent with being a mere instant. And then she said that she didn't have time, you know, it wasn't like an extended staring at him, inspection of him, or anything like that. She says she didn't have time to count freckles or to see if he had effeminate eyes. She was still unhappy about that effeminate eyes comment, and had to kind of throw it back at him. So once again, Mr. Baldwin pushed back on that, asked her, sure, you want to review the transcript to try to refresh your recollection? And once again, no, I'm good. I just don't feel like that probably went over well with the jury. I can't imagine it did. It came across as probably knowing that it was going to be wrong, that it was going to be in there, and that then she was going to be confronted with having to reconcile. She apparently did say this thing during her deposition, but it really did. It seemed like it offended her that the idea that she would say that he had effeminate eyes. So then Ms. Diener did redirect. That was all the cross. She went back to redirect. Ms. Diener clarified that in the interview where she talked about him wearing a tan sweater, that it was more of a hoodie that she had intended to describe, like a pullover sweater that had a tan hood. She had seen a hat on him, and it seemed like an odd hat. She said she's a baseball cap girl. That's pretty much what she's familiar with. And so the man that she saw, his hat had a bill, but she could have mistaken his hair for part of the hat. Like she could have just maybe not seeing exactly where one ended and the other one began. She said she saw the bottom of his ears, but he was hunched, and so she wasn't sure if perhaps maybe the hat was being moved, or just being compressed, or something, maybe being lifted, and that was part of what was making it look weird to her. She said his shoulders were hunched, his hands were in his pocket. His posture she described as just weird and sketchy, and when asked to draw that out a little bit more, she said it was like he was kind of curled in on himself, and she sort of demonstrates like a very, shoulders curled forward kind of posture. She reiterated on redirect that she had been ID'd from a ping, and that the police had checked all of the numbers. And she only knew this because all of her family lives nearby, and she had talked to people on social media about how all of them had been pinged during this investigation. And then during one of either the first or the second interview, the officer had also said that her phone had been pinged. So yeah, this really seems like an open door to me, because it's just something that's out there, and the jury is going to have questions about it. What does that mean about Mr. Allen? Did Mr. Allen also ping off of this tower? Because that's something that we would want to know if we want to know if he's Bridge Guy or not. If he did ping off the tower, it sounds like the issue is that that's not particularly helpful information, because it would just mean he's in Delphi. This is the same issue we're dealing with if you're following Koberger out in Oregon or out in Idaho. I'm still a little sleep deprived, but not quite as bad. Out in Idaho, it came up during the probable cause affidavit. His police are trying to ascribe locations to him based on pings, but these cell towers are there's not very many of them. They're very spaced out. They don't have a lot of overlap, so they're not able to triangulate location very well, and that means a ping can only really put you in the radius of that particular, the coverage of that particular tower. And the coverage can be 10 miles, it can be 20 miles, it can be like 30 miles. Some of them can be quite large. So it's not a particularly precise piece of information if you just have a ping on a phone. During the second interview, she said she had noticed that a portion of the interview with the officer was missing. She said it was 1 to 1.5 hours, and she saw this because she was reviewing her deposition in preparation for her testimony. This also seemed to confirm to me that there had been witness preparation that took place, because that's pretty typical. What will happen is the prosecutor will bring the witness in if they've given prior statements or, taken depositions or something like that. Maybe they gave a written statement to police, anything like that that's on record. The prosecutor will give it to them so that they can review it and, make sure that they remember what they said before they go in to testify. So she reiterated that during that interview, during the missing session, is when she told the police officer about the mud and blood. She said she was provided a picture of the bridge guy that was already seen in the media, and she had marked on that during the interview where she had seen mud and blood on him. So that was published to the jury, this exhibit. She described it like we couldn't see the markings. Once again, this is a paper exhibit. It was provided to the jury with copies. One of the things that's really annoying is that they have an overhead projector there at the prosecutor's table. And I know this because when I stuck around at court yesterday evening, waiting to see if I was going to get to see the big photo of bridge guy, I saw them working with it. I saw them like messing around with it. So they have the capability to be able to put these things up on the big screen where everybody is able to see them, but they're not doing that. And they didn't do that with this photo. So I don't know exactly what is on the photo and exactly how she marked it. But what she described is that it sounds like there's a couple of markings on the leg. And so according to her, she was indicating that the bottom part of the leg is where there was mostly blood. And then above that was mud. And then she had drawn another line to indicate the hat. And she said the coat was dark enough that she wouldn't have seen blood on the coat. It was just caked with mud. She described him as extremely muddy, like so muddy that she, thought he had certainly been down by the water. Again, maybe had fallen off the cliff. And that there were the blood that she saw was like drops. It was like splatters of blood. And it wasn't at this point. I think it was later. I'll get to that. So then they just went through. She reiterated in the first interview, according to her, she said mud and blood. Second interview, she said mud and blood. And then in the third interview, they were focused on the blood at this point because that's what it was important. And so didn't talk about mud. That was her explanation for what transpired. Mr. Baldwin then had recross. And so he clarified, the reason you didn't say mud in the interview is just because of what you were asked. And she said that was just what they focused on when they questioned me in the interview. He reiterated, you said mud 13 times in the second interview. And then he's challenging her now. He's getting a little bit more pointed in his questioning. He's still not mean, but he's and maybe she would see it that way. He is being more pointed, a little bit more somewhat more aggressive. So he says, you said mud 13 times in the second interview. And at that point, the video was cut off. And that just happens to be when the only time, during the interview that you mentioned the blood. And that we just have to take your word for it, that that's what happened in this interview. And yes, she was in agreement with that. We then had some jury questions. What was your age in February of 2017? She sat there on the stand and ran through the math in her head, but she came up with 27 or 28 or possibly 26. They asked, how wide is the road? She described it as a fairly typical country road. So two pickups can pass each other on the road. But she said one of them, if they're crossing, one of them would have their wheels off the road. So it sounds like she's describing a road that's a little bit narrow than a standard, one lane each way kind of road. I don't know that I agree with that, at least the portion of the road that I went on. It was just a perfectly normal width road. The jury asked, can you describe why you say you saw blood spatters? She seemed a little defensive at this too. She said, because I saw them. And then they asked, how did you tell blood? How could you tell blood from mud? Her description then at this point was that the man was wearing whitewashed jeans. This is very different from the description that we got from the other witnesses who saw the bridge guy. They were very clear, dark pants. But according to her, it was whitewashed blue jeans, and so that's why the blood showed up in particular on the jeans. She was asked how close to the man were you? Like, how close did you get? She said less than 3 feet away. Less than 3 feet away. That is a very hard one for me to buy, because if you're blowing past a human being in your car at 35 miles an hour and he's only 3 feet away, you're coming real close to hitting that guy. And that's, again, just not really what she had described. She had described he's walking on the side of the road. She's walking over in her lane, or she's driving by over in her lane. So you'd expect at least the distance of a lane on the road between them. So the attorneys get to follow up to the jury questions if they want to. So Mr. Baldwin followed up to this question, said, you previously testified that he was 20 feet away. And she explained, well, that was at the long point, and that as we approached, the distance got shorter. And then at this point, she concluded with a comment. She was very irritated at this point and really let it show. She said, essentially, I'm driving. I didn't get out a ruler and be like, hey, you're 17 inches away. She's like demonstrating this, facing the jury, very animated, very angry. Of course I didn't do that, like it's stupid. I mean, that's not what anybody asked. No, I was driving. That was the conclusion of her testimony. I felt kind of bad for her. I don't think it probably went over very well with the jury. It was just very defensive, very confrontational, very angry, and resistant to what seemed to be, I mean, twice she got refreshed that, no, you didn't say the word, you didn't say the word in here in the transcript, to the point where when she's being, offered the transcript again to corroborate this, effeminate statement, no, she wouldn't even allow it. And it was just kind of left at that. Now, the defense did not put those transcripts into evidence or put the page where she had said that into evidence. This may have been an oversight, may have been a mistake. I would have done that. I mean, I'm assuming that this is allowed in Indiana because that's fairly standard impeachment with a prior inconsistent statement. Typically, the way your prior statement comes up, comes up one of two ways. If you don't remember making a statement, then you can review it to refresh your recollection. And in that case, the document or whatever it is you're looking at, it doesn't come into evidence. It's just there to serve as a memory trigger. And then you will either, do you remember making that statement now? Well, if you read it there, typically most people will say yes. Sometimes they'll still say no. Well, it says that, but I don't remember it. So then you move on to, do you deny it? Do you deny that you said that? If you watched any part of the Alec Baldwin trial, Alex Spiro was a genius. He was absolutely extremely skilled at laying his foundation to be able to admit a prior inconsistent statement. And that's how you do it. If somebody just says, I don't know if I said it, I don't remember if I said it, then you don't have enough of a foundation because they haven't denied making the statement. So he would just come out and explicitly ask them, do you deny making that statement? And then they got to think about it. Yes, if they say yes, deny it, then you get to put that transcript into evidence. And then it's there in black and white. The jury knows it's there in black and white. They can read it for themselves and see, oh yeah, it does say effeminate eyes. If you don't deny it, then the jury just has the ability to accept that as essentially a concession that, well, yeah, you probably did say it then. You're not denying that you said it. The guy's, the attorney is saying that you said it. If you didn't say it, you probably would deny it. So Alex Spiro did an outstanding job of illustrating a very effective way of being able to handle that, because it can be tricky. If you watch Delphi Heard, one of the issues there was issues with dealing with foundation for prior inconsistent statements. We lost a whole bunch of Jennifer Howell testimony that was quite compelling testimony because Johnny Depp's attorneys failed to lay the foundation to impeach Amber Heard's sister Whitney with her prior inconsistent statements. So Mr. Baldwin didn't do that. He didn't get the actual transcript in evidence. I only wonder if that was a mistake, just because now they don't know for sure if she said it or not. They don't know what to make of it. But that said, her demeanor, unfortunately, it really didn't do her any favors. By the time she was concluding, I mean, like I said, she was angry. She was very visibly angry and, demonstrative. I didn't have a ruler or something. And even the jury seemed like they were a little, wow, like this is a lot. I don't think they're probably going to give it a lot of weight. It's not that I think anybody is necessarily like, oh, she's lying or anything like that. She probably is very well intentioned, sincerely believes, what she's testifying to. But it's just too difficult to reconcile with what seemed to be the inconsistencies from the prior statement. So not clear that the jury is necessarily going to give her testimony a lot of weight. Give me a second here. Still getting caught up on my hydration. So our next witness was Dr. Roland Kaur. He was the forensic pathologist. He is the one who did the autopsy. And he was so extremely soft-spoken that we had, once again, a really, really hard time hearing them. So fortunately, most of what we had the hardest time hearing was just kind of the background information that you kind of always get with these witnesses. They explain what forensic pathology is, what are the subspecialties, how does it work, what do you do, what's your personal background and training and experience, and so forth. So he described all that. I got some kind of bits and pieces of it. Basically, he had done a few different things. He had mentioned, like, at some point he was doing some surgical work in stents. It sounded like he was saying that he moonlighted for that, but he was doing residencies. He did a residency in anatomical pathology and a residency in clinical pathology. And at some point, he was encouraged to consider running for coroner because he had the experience of doing these autopsies. So he ultimately served 4 terms as a coroner. Didn't catch which county, but because of term limits, I guess they have constitutional term limits in Indiana. The way it worked is he served 2 terms, then he had to sit out for 2 terms, and then he was able to serve 2 more terms after that. And so in the course of that, he continued to do autopsies and did them for multiple counties. He described himself as always trying to teach during an autopsy. They're often attended by law enforcement and stuff like that. He did seem to describe himself as kind of an educator, and we got that vibe very much on the stand. He had a lot to say. He did like to talk, but it was okay. I mean, most of, at least what I could hear, was I found it very interesting. And so he does sometimes go to crime scenes because of his training. He will sometimes see things that others don't, but it does not. There's no indication that he went to this particular crime scene. So he then described the process of the autopsy. This is something that we have heard before in many murder cases. First gets contextual information about the case, transports the body to the morgue. The body is on the autopsy table. They open the bag. They observe the condition of the body and the clothing. They then observe the skin, hair color, look for any obvious wounds, signs of trauma, and things like that. At that point, they remove the person from the bag. They undress them and photograph them. They inspect the clothing, look for like holes in the clothing, like a bullet hole, a cut where perhaps a weapon would have been, blood, obviously, things like that. They make notes of any insect activity or other secondary damage like that. Next step, they clean the body, but he stopped to clarify that before you get to that point in a case where they are going to do a sexual assault exam, a kit, they do that first because the washing the body is, going to get things wet and going to move stuff around, and so you would increase the risk of contamination or potentially losing evidence. So they do those kit components first. We got a very important answer here. The kit is what contains the basically materials to do the clippings, the fingernail clippings, the swabs, the scrapings, and stuff like that. So that is in the sexual assault kit. That's why we didn't hear about it when the crime scene investigator the other day, Olahai, testified about all those items that were put into evidence, because he just identified the kit and they are components of the kit. So enormous relief to me to hear this was not like some oversight, that was actually part of the autopsy, although there was a wrinkle that I'll get to in a moment. Next step, they measure wounds, make illustrations. They note what type of wound it is. Is this an abrasion? Is this a contusion? Is this an incision? That type of thing. They take a blood sample from the femoral vein. He went through he is very much an educator, went through kind of a long description about why you do it that way. It's a less contaminated sample of blood. And then there's this phenomenon after death where because of how the blood settles, that if you're doing like a toxicology screen or alcohol or something like that, certain kinds of drugs, I guess, it's like it can change the concentration. It makes it seem like maybe they have more of the substance in their blood than in fact they do. And it's just based on the way that the blood functions after death. So the femoral vein apparently helps, that not be an issue. And then after all of this, they proceed to the internal exam, the dissection, that helps them to get more information about the wounds, to make better identifications of the wounds. They note if there is disruption to any of the organs, if they're normal. described how they do the incisions and stuff. He made a point of emphasizing the way that he does the incisions, particularly the abdominal incision. You hear about the traditional Y-shaped incision. He says he does it differently. He does it more like football posts, because that makes it easier to seal up for and handle for the funeral director for purposes of being able to make the person presentable. And likewise described how he does the incision on the scalp, because they peel back the scalp, basically remove the skull cap. That's how they get to the brain. And he does it in a way that makes it easy to put all that back into place and suture it up. And then the person still remains presentable. Said he's done, at this point in his career, between 7,700 and 7,800 autopsies. That is a lot of autopsies. I didn't do the math. One a day for 20 years, something like that. I mean, that's a lot. That's a lot. So he obviously had photographs from the autopsies that were taken. We did view some of those. Clarified that there were tons of photographs taken during the autopsy. He goes through and selects the ones that tend to be most pertinent for what he is going to be talking about in his testimony. So basically, the things that were significant, and so there were no photos that were displayed or introduced during the internal examination. We only had photos from the external examination. So he did the 2 autopsies. At this point, he is up at the screen because we're going to start going through. Well, actually, we weren't quite there yet. He was doing a little bit of a summary. So I did catch most of what he had to say, but there were some little parts that I couldn't hear. But so he did describe the first autopsy that he performed. He did on Abby. So the first thing he does is estimate height and weight. He made sure to distinguish it's actually not a height measurement, it's a length measurement, because the person is lying on the table and they do a length. He also does not weigh the person. He does a weight estimate, and he says that's just based on his experience, how many of these that he's done. He has the ability to give a pretty good estimate just based on the person's physique, for lack of a better way to put it. So Abby was 64 inches and weighed about 95 pounds. She had been in a black hoodie, pair of blue jeans, a gray sports bra, and a black regular bra, and what he described as a pink camisole. The external wound across her neck was approximately 5 centimeters long. He said that when muscle fibers are cut, they tend to retract, and so that causes gaping of the wound. That is very consistent with what we saw in the photos of both girls. These wounds were very, very gaping. He measured it as about 2 to 2.5 inches wide with that gaping. So it was very dramatic. Just a single wound. So he used the kit. He described what the kit entails. There's a blood sample, there is a vaginal wash, there is a vaginal swab, oral swab, hand swab, an external genital swab, an internal genital swab, the fingernail scrapings, hair, pubic hair, a saline syringe. I'm not sure exactly. I'm not sure if that was related to the vaginal wash or not. There's combing of the pubic hair to look for like debris or whatever. So a lot is wrapped up in this kit that when we just see the kits coming into evidence, doesn't give you all of this detail. So now we have all of this detail about what that entails. The wrinkle with the scrapings is that he said Abby was she bit her nails very severely, and so they were so short they were not able to take scrapings. That said, from the way he described the kit, they would still swab the hands. So that that presumably was done. I'm sure we'll hear more about that when we start getting into the witnesses from the lab, the analysts who handled this evidence and processed it and tested it, and are going to come in and tell us about the results. The hairs that were found on her, he did say hairs multiple, so we already knew about the hair on her finger. There had been testimony about another fiber that was found on Abby. I'm going to see if I can find it real quick in my notes from yesterday. I don't want to spend too much time trying to hunt it down, but I just it would be helpful, I think, to remember where that was. A strand of fibrous, oh no, that was from Libby's hand. Let's see. A trace fiber from Abby's upper left arm. That was the other one. So we had the hair, the fiber that had been entangled in the finger, but then this other one was a trace fiber. It was just mentioned, a trace fiber from Abby's upper left arm. And so I'm not sure if that's what they mean, if that's a hair, if that's why we're getting hairs, plural. But he did address them, said that they had been transferred from another source. All of that stuff went into the box. He said there was no injury that was suggestive of traumatic sexual contact. So nothing overt that he saw that would indicate traumatic sexual contact. He says that does not mean that there was none. This is very important because that is. It comes up a lot in these types of cases. Injury is not a very good metric for consent or not consent, or just, really anything at all. These parts of the human body are elastic. They're made to be, fairly resistant to injury. I was kind of curious because I don't know if there's actually good science on this or not. Some of you in the chat may know the Tanner scale. There's a Tanner scale that establishes it kind of sets sexual maturity. It helps you stage where a person is at in sexual maturity, like in going through puberty. From very immature, very undeveloped to fully mature. There's different identifiable stages, five for both men and for women, that can just kind of help you identify where somebody is on the scale. I don't know if there is like good information about whether being lower on the Tanner scale would tend to maybe produce more injury. I'm just thinking like, yes, adult women, they can take a pounding. I just said it. Sorry, I said it. They're just made. That's what we're made for, but young women are not. And so I don't know if there's any real correlation with injury there or not. But in general, it's very common to have cases, non-consensual, no injury. Also very common to have cases, consensual and injury. So they're just not necessarily a good indicator of whether there was contact or not. We're probably going to want to rely mostly on the swabs from the kit to be able to make that determination. But still, I am very pleased to hear, relieved to hear, glad to hear no overt signs of injury, because that would be extremely bad. So he saw no trauma. He described the wound as an incised wound, so meaning it's a cut. He distinguished this, he being an educator, he distinguished this from a laceration. A laceration is a blunt force injury, and so that is technically a tearing. That's distinct from an incision, which is something that is a sharp force injury. It comes from a cutting instrument. So he described that three types of sharp force injuries. There is a incision, which is something that is longer than it is deep. There's a stab that is deeper than it is long, and then there is a chop where, essentially something is taken off. So they can tell the difference between an incision and a laceration because the laceration has abraded edges and the incision is clean. So the only wound on Abby at all was this single incision. They looked for defensive wounds. He described how a person is just instinctively, when they're being assaulted, they are going to take a defensive posture. They're going to try to defend themselves. And so they will typically always look for injuries to the extremities. So we saw no defensive wounds, no blunt force trauma. There was something that was very interesting, had not heard about this before. He said there was a very faint linear mark across her face, as if cloth or duct tape had been there, perhaps across her mouth. He said there was no adhesive residue, however, so didn't sound like it was tape. Otherwise, there's no ligature, no wound like that, no sign of restraint. Couldn't tell specifically the timing of when this mark would have been made. It was very faint. He just placed it as peri-mortem, meaning right around the time frame of the death process. Said the wound, you couldn't really tell the direction, but there was some indication because on one side of the wound, this was a horizontal wound. One side of the wound, there was just a slightly different shape and almost a little bit of, almost like a bruise, almost a little bit of a bruise. And so his assumption was that the direction of the wound went right to left. That the knife would have entered first on the right, it would have caused that different shape and the small bit of bruising at the point of entry, and then is drawn to the left, and that's what causes the wound. The internal injury that resulted from that was a partial transection of the left jugular vein. He then described Libby's injuries. Libby was cut multiple times. She had a transected right carotid, a partially transected right carotid artery, and then I forget. One was partial and the other was full. I think the right carotid was partial. The left carotid artery and the left jugular vein were fully transected, meaning they were completely cut through. So he described the difference between these. The carotids, are where you feel your pulse in your neck. You have three of them on each side. So two carotids. There's a common carotid, and then they split into an internal and an external carotid. And so those three pieces, common, internal, and external, both on both sides of the body. And then the jugular is right next to the carotid. The artery is what, as we know from basic biology, the carotid is what brings the oxygenated blood from the heart. The jugular vein is what brings the no longer oxygenated blood back into the heart from the extremities. So because the arteries are carrying the volume of blood from the heart, they are much thicker. He described them as muscular and elastic, whereas the veins are not thick like that. So the arteries, because of that quality, they're similar to the muscle, where they will contract when they're cut. They have that elasticity to them that then reacts when they get cut. We took our recess at this point. The judge is being very good about these regular recesses now that we have the jury. The jury is getting their regular breaks, so we all benefit from that. When we came back on the bench, everybody in the gallery had been ask, like, can you hear him? I was asking some of the media people get the front row at the courtroom, so I was asking some of the folks I've been talking to in the media, were you able to hear anything he said? Like, we couldn't hear anything at all. Nobody could really hear this man. And so everyone was kind of, well, hoping, is somebody going to say something? Will somebody please, ask him to bring up the volume, because it's just extremely difficult to hear a lot of what he's saying. Some of this stuff, like these details, the carotid artery, the jugular vein, and stuff like that, I had to kind of fill in after the fact, after we got a little bit more context, a little bit more detail, and I was able to, like, okay, that's what he was saying back then. Really, really difficult to follow it all in real time. He gave all kinds of details that I'm sure that I missed because we just could not hear them. So when we came back in from recess, we got a statement from the judge. It just said a lot, I thought. So she addresses the fact that we can't hear them. Her statement is that the media has the best seats in the House, so we trust that they will report the facts that are being elicited, and that it's important for the jury and the parties to be able to hear. But to all of the rest of us, apologies to everyone in the audience behind the credentialed media, those of us who can't hear. So just a little nod there to the preferable treatment that the media is getting in this case now, getting their front row seat and calling out that credentialed piece. Not us unofficial peons over here. Those credentialed folks get the special treatment. So they get to be positioned where they can hear. We saw at this point, this is when we started transitioning to seeing the visual exhibits. So this was helpful because the doctor got up and went over by the screen so that he could, use the pointer and demonstrate things. And that meant he had to project his voice over to the jury, and the rest of us were now able to hear significantly better because he did that. So we saw some diagrams of the injuries before we saw the photographs of them. We did see the photographs of them. So now I have my notes a little bit. So yeah, so the earlier part, ignore what I said before because I do think I got it wrong. When I could hear him better, Abby had a partial transection of the jugular vein, like I indicated. It was on her left side. Libby had a partial transection of the left carotid. So the left side was a partial, and then the full transection of the carotid and the jugular vein on the right-hand side. We saw several photos of Abby, and it wasn't clear to me exactly why we saw some of these photos. There was an interesting comment that was made. So we saw Abby on the autopsy table. She is still clothed at this point. She's actually still in the bag with the sheet. The sheet that she had been wrapped in is still underneath her. You can see some pooling of blood on the sheet. There's smears. He's pointing out there's smears of blood on her right arm, and his explanation for that is that was probably from the clothes coming off. I wondered if he meant the clothes going on. I'm not sure. It's everything else being equal, if he had just said that, I would assume he meant when they took them off in the autopsy. But the problem is that we are now, the autopsy took place on February the 15th. So we're now somewhere between, 2 and 3 days, or 1 to 2 days after, like full days after they were dead. And so you would think that the blood on the arm would have already dried. There would not be a smear from removing the clothing during the autopsy. So I don't know if he was making a reference to being clothed and unclothed. That does make sense. It definitely makes sense as an explanation. If she had blood and then was clothed, that would cause the smear. That's something that I will be filing away in the back of my mind for when we get those evidence technicians and those analysts in to hopefully tell us about the clothing and trace evidence on the clothing and what we might be able to ascertain from it. We saw the measurement of the wound and the description of the very slight abrasion was on was on the wound, possibly from the entry. More than likely, in his view, a right to left. So it leaves a little bit of a blunt impact as the hilt strikes the skin, is the way he described it. It was about an inch or so deep. Some muscle fibers were cut, but not a ton. Some subcutaneous fat was cut, and then confirming the partial transection of the jugular vein. Then a photo where they basically stretched the wound back to what its normal configuration would have been because of that retraction, pulls it open. So they stretched it out to kind of show, how it matched back together. And that, I think, was showing like the true length of the wound. We saw a very close up of the wound to just show exactly where it's placed. It's just to the center line, like just to the left of the center line of her throat. And like you said, it's 5 centimeters long. It's about 2 inches long. It's quite a long wound. And on this photo is where we were able to see the marks that he pointed out, the linear marks. So now this time, previously he had suggested maybe tape or cloth or something like that covering her mouth. But this time he pointed out that they were actually below. There was like the primary mark, and there was a little bit of a mark below it. So it was more on her chin. And so now he was suggesting that, saying that it suggested that her mouth was not covered. I found that confusing. I wasn't quite sure how to reconcile his testimony from before the break and his testimony after the break as far as the mouth being covered. Still no indication of any kind of adhesive. So he didn't seem to think it was tape, but didn't rule out cloth. And so then with that raised a question of, in my mind, was the handkerchief. They had recovered a handkerchief from the pond, from the creek, when they were recovering all of the other items of clothing, the things that had, come at least a little bit way downstream and gotten entangled in the roots. A handkerchief was among those things. And so I wondered, maybe, possibly was this some kind of gag? One of the things they didn't do in the case that I wish they had, because it would have been helpful at this point, was to have somebody identify, like somebody from the family, identify these pieces of clothing as whether they belonged to one of the girls or not. I would have liked to have known, this handkerchief, where did it come from? Did it belong to one of the girls? Because if it didn't belong to one of the girls, then there's a possibility it belonged to the killer. And I just thought of that because, the possibility of it being used as a gag or some type of restraint, some kind, maybe it was wiggled down. I don't know. I'm trying to make sense of the evidence that's presented, and I don't have a good explanation for why she would have some kind of, cloth or tape or something along the bottom part of her chin, but not covering her mouth. The suggestion, though, of the mouth being covering, that was very new information for me, very new suggestion that was part of the story of the crime. Seems difficult, if that is the case, again, to reconcile with the state's theory of what happened, of basically what was going to be an attempted rape that then he got interrupted and so killed them instead, because he was short on time. I don't know when that part of it, the covering the mouth, would have taken place. And also, this was only Abby. Abby was the only one who had these marks. He didn't describe any similar marks like that on Libby. So anyway, at this point in the interview, in the testimony, he's indicating he doesn't think it indicates that her mouth was covered. It was below that. We then saw a picture of Abby's back that was there to show the lividity, the livor mortis. And she did have some. You could see. He explained that because the body, like the blood vessels, are like depressurized essentially. At death, the heart stops beating, and so the blood is not moving through those vessels anymore. That when there's pressure on them, like from the point of contact with the ground, or if there is something like on the ground that they're on, that the blood will not tend to pool in those areas. It will pool around them. It will move to the low points where there are no pressure. So she had some spots on her back that he was indicating appeared to be indicative of lying on her back and potentially being on some debris. So according to him, because of the rate that livor mortis sets in, it would indicate she had been lying on her back for some time. What we didn't get an answer to, and nobody asked, and I was curious about, was whether any steps were taken through the collection or storage, until the time that the autopsy occurred to prevent the livor mortis from progressing. Like if they, for example, bring her in and have her in, like a refrigerated type of setting, is that going to, my understanding is that that's going to, at least slow those processes substantially. So the implication, he didn't specify. I'm just, I think that would be normal process. So I think that would be the case. But so he didn't specify like when, what time the bodies arrived. So we just don't really know how much of this would have progressed after the bodies had already been recovered. It would have been nice to have had that documented at the scene. We had one photograph at the scene that showed showed Libby being lifted to the side. They were inspecting the ground underneath her. She was very, very covered in debris, so it was hard. It was hard to see anything. There wasn't any obvious lividity in those photographs, but it's also not clear that we would be able to see the spots where lividity would have occurred. So that is another, I would have liked to have seen that. It would have been helpful. He said that because it takes several hours for the lividity to become visible, but if it becomes fixed, it has to be in that fixed position for about 8 hours. So that gives us a time frame of basically being on the back for 8 hours, but we don't know, when that started and how long that continued after the bodies had been collected by the crime scene investigators. Libby then, there was one other detail from Abby's autopsy, which was a small abrasion, very minor abrasion on her lips. Didn't tell us any more than that. Nothing about like what might have caused it. Nothing about, was this like was this like normal chapped lips, or was this something else? We don't know. This again potentially raises a little bit of a specter of a gag. Like was she gagged? We don't know. We don't know. We don't know if it's chapped lips, if she had slightly chapped lips before she went on the hike. 'Tis the season in February. I don't know about you guys, but yeah, I get super dehydrated in February. Real common to have things like that happen. So, something to note, but didn't really get answers as to the significance of it and what it meant. It's just another one of these open questions, but does raise that specter of a possible gag. Libby was also 64 inches long, estimated at about 200 pounds. He paused to clarify that between the autopsies, he goes back and writes his reports while they're still fresh in his mind. He's got basically templates, so you just sort of fill in the parts, that you remember. He doesn't have to sit and write a whole 20-page thing. And then while he is doing that, his autopsy assistant will, return the organs to the body, suture up the incisions. He does say return the body to the cooler. So yes, that does indicate the body was in a cooler before. Just when did it get in the cooler would be helpful to know. Wash the table and the instruments. I assume he meant sterilized. He didn't specifically say sterilized though, but I've got to trust that he meant that they would sterilize the instruments in the table so as to not contaminate the next autopsy. So with Liberty, likewise, they did the assault kit. No sign of any type of trauma. He clarified that these kits do include some extra swabs that can be used just for miscellaneous purposes. This came out because he indicated that there's no, like, the crime scene investigators are not over there collecting their own swabs. And so these other swabs that we had noted in evidence for Libby, from the breast, from the thigh, like a few different miscellaneous ones, he was attributing it as likely being to that, these miscellaneous ones from the kit. I don't know that I believe that, though, because they weren't in the kit. They were separate from the kit. Everything that was from the kit went back into the kit, and that's the standard practice for that. So I think it's probably likely that either the crime scene investigators took their own swabs and packaged them, or he took these additional swabs during the autopsy and maybe just didn't remember. I don't know, but there is a little tiny bit of a question about the exactly where those other swabs came from. So their provenance, like where we need somebody, I would, it's always preferable if we can have somebody specifically identify, okay, this swab on the hands, where on the hands, the hands are big. Was the swab here? Was the swab here? Was the swab, on the back of the hand? Was it on the palm of the hand? We don't know unless we have the person that took the swab who can tell us this is where I swabbed, because they didn't put it on the label. They just said, from the hand, from the breast, from the thigh, so forth. So I hope, on the one hand, we want evidence, we want results, we want something from those swabs that can help us identify who is the perpetrator of this crime. On the other hand, it may be difficult for that information to be useful if we can't track down exactly where these swabs came from. Libby as well had no defensive wounds and no restraint wounds. She had primarily the wounds to the throat. So there were at least 4 different wounds, and there was a possible 5th one. It looks like there are 3, and the reason why is because one of the ones, the one that was on the far right-hand side, it was actually 2 separate cuts, almost like in an X shape. And he described it as if, somebody had made a cut and then gone back to, like, do it maybe deeper or something like that. And it doesn't follow exactly the same line as the first cut. So from a distance, kind of, it looks like it's just 1, but on close inspection, it is in fact 2. Libby's wounds were mostly vertically oriented, which I found strange. Again, I've never seen that. So it's basically 1 on the right side, 1 close to the middle, 1 over on the left side. Obviously the, one being actually 2. We saw a photo. We also saw a photo of Libby when she was on the table that shows that her hands had been bagged. This didn't get mentioned by any of the crime scene techs, or, I mean, we didn't hear from if there were like firefighters or first responders or somebody like that who was in charge of the transport. She was in the coroner's. Had the coroner's van out there, as far as we know, but we didn't hear from any of those people about their process. You know, what they do when they're transporting a body. So somebody bagged the hands at some point in time. We don't know who. Generally a good thing that happened, but once again, would be awfully nice to know exactly when that took place, because the CSI, the crime scene investigators, they described that they wrapped her in a sheet and then placed her in a bag, wrapped up in the sheet and zipped up the bag. So if the bag is closed and nobody's mentioned bagging her hands, I don't think we would probably unzip it, unwrap her, and bag the hands and then put it all back together. Maybe we did, but it seems more likely to me that just the bagging of the hands got overlooked before she was placed in the bag, and just it didn't get mentioned. She also had some smaller kind of secondary injuries. She had what he described as a very superficial incision that was just below her left shoulder. It was kind of like over in this area. It was very small. I would say maybe a centimeter. He didn't give us a measurement. That's just kind of my guess based on the eyeballing it from the photograph. And then some very tiny abrasions that were just below her throat, and a small abrasion that was between the wound on the left-hand side and the wound on the center. So like basically right about there. So, okay, so it was the wound on the left. It was not the one on the right. It was the wound on the left that had the overlapping X-like pattern. So it basically consisted of two passes that looked like one. Then there was one that was basically in the center, but slightly still to the left side. And then the one that was over on the right side. He said it was possible that there were also two passes on the center wound. That's why it's 4, maybe 5 incisions, but he could not be certain. And the reason why is, he said, because so if the victim is alert and is conscious, it's almost instinctive that there is going to be some kind of movement, some kind of reaction. I mean, similar again to the defensive posturing. And so that can affect the wound. He described, he gave an example of like if you're stabbed and you react and you jerk, it's going to twist the knife, and that will create a different shape of the wound. It will create like more of an L shape than just like a straight, completely passive incision goes in, straight out. No, you move and it changes the shape of the wound. And so it's possible that that's what the situation was with the wound to the center part of the throat. Could not say definitively if it was one incision or two separate ones. We saw on the left-hand side, the wound, there were these marks at the edge of the wound that he indicated it appeared like a serrated knife. It had showed scalloped edges. But then he said that he has thought more about it since he did this, since he did his deposition, basically in very recent days. He's thought more about this conclusion that these were serrated edge marks. So we could see the wound, and the way it looks like is that there are these lines. I mean, like, they're distinctive lines, very, very linear pattern. The very bottom one, though, is like slightly differently shaped. It's like maybe a little bit thicker. but otherwise they're fairly consistent. Each mark is about 1 to 1.5 millimeters wide and about several millimeters in between. And they're right there adjacent to the wound. So we can see these very clearly. So he indicates it's probably he's changed his mind because with a typical serrated knife, the deepest part of the blade is in the center, whereas with this one, the linear pattern suggested it was that one that was on the edge, like the very first one that appeared to be that shape, and so he changed his mind, thinks maybe it's no longer a serrated knife, that it would come from the hilt or perhaps some other part of the weapon. And that these, he thought, looked maybe more like abrasions than like the pattern that you would see from a serrated knife. I would think that would still be an abrasion, but I don't know. So just because that largest one on the edge didn't have the same pattern, it suggested a different cause. So he acknowledged that in his initial report, he had indeed said a serrated edge, but then on a later part of his report, he had suggested that it was serrated like, that it was not typical or classical serrated knife markings. So because of that, he thought it could have been something else. Now they did something a little bit unusual here, and I put the notes in my margin because I'm like, why are they talking about what he told Mr. Baldwin and Mr. Rossi? This is how Mr. Luttrell was doing the questioning. This is specifically how he was asking the questions. Like when you told in your deposition, you told Mr. Rossi and Mr. Baldwin that it was a serrated knife, but you've reconsidered now. And it became clear because he says now that he had indicated that perhaps it was a handle or a hilt of a weapon that had a pattern. And then he says what got him thinking about this was he went out to the garage and he had a box cutter. And the box cutter has this plastic attachment on the side with a thumb grip, and the thumb grip had some parallel lines on it. And so he was thinking about that, and now thinks maybe those were from the side of a box cutter. Well, this is quite a remarkable shift in the testimony, isn't it? It became clear, as I'll get to, that the reason why Mr. Luttrell was asking about what he had told Mr. Baldwin and Mr. Rossi is because he had not communicated this new theory to the defense before he testified on the stand today. Before he finished his direct, he talked about what would be the physiological effect of these injuries, what would the effect be on the body. And so generally speaking, there, are going to be some common responses. So the first thing, you're going to feel pain, these nerves, you're going to feel that. And there's going to be an autonomic nervous system response, a fight or flight response. And so these are, heart rate speeds up, breathing tends to get shallow and fast, blood vessels constrict, these common reactions that occur. In the case of Abby, because this was an injury to a vein and not an injury to an artery, it's not pressurized, and so that means the loss of blood would have taken time. It's not something that would have been instantaneous. And so what happens is that there's passive blood loss. As the blood volume in the body decreases over time, that causes the blood pressure to decrease. So then what happens is the heart rate will speed up. The heart will try to keep up, so the heart rate will go up to try to keep the pressure maintained, and then basically the body goes into shock. And so the shock system is trying to prioritize getting the blood to the areas of highest priority, which is the brain. So what happens is some of the less important organs will shut down, like digestion is no longer a priority. We don't need to be sending blood there. We don't need to be sending blood to the liver. We're not worried about like filtering it and stuff like that. We're just worried about the priority of getting it up to the brain. But ultimately, with the continued loss of blood, the pressure continues to fall, and that will result in loss of blood to the brain, loss of oxygen to the brain from that, and there will be a loss of consciousness and eventually loss of brain function, which will be basically the cause of death at that point. Without the brain function, there's no longer signal to the heart to pump and all of those other activities to occur. So that's the general process of the death. There was a point during this where Mr. Rosie was handling the cross-examination. He was objecting to leading questions, and Mr. Luttrell, I call him Luttrell, but it's really Luttrell. I don't know exactly how to pronounce it. I catch myself saying Luttrell because it sounds like it's spelled with an E at the end, and it's not. It's spelled with a U. Anyway, he really struggled to adjust. He was not. He is not Mr. McClelland, okay? He was not. Ms. O'Shea was able to adjust very quick on the fly when she wasn't able to say, do you agree? She was able to switch very quickly to, is it true? Mr. Luttrell did not have that quick adjustment. He had to abandon his line of questioning because he couldn't really think about how to get there. And it was unfortunate because it was a question I had wanted to know the answer to. He was asked to give a ballpark estimate of the process of getting to unconsciousness or death. I didn't like this question. It's compound. That didn't get answered. That didn't get objected to. So his answer was that the ballpark estimate would have been 5 to 10 minutes, maybe longer. And there's just variables involved. It would take longer if the person is lying down. If the person is moving, up and moving around, it would be faster. So the question, then the follow-up question was, how long would it take to reach unconsciousness? That's where the objection came in. And because he couldn't think of a non-leading way to ask this question, we didn't get the answer to that. So 5 to 10 minutes was the answer to the compound question of death, unconsciousness or death. But we don't really know which one. So Libby would have gone through the same physiological process, but because it was all three vessels and because some of them were arteries, it would have been more rapid. So he said that there's instinct. The first instinct is going to be to apply the hands to the wound. So that's the theory for the bloody hands, Libby's bloody hands. Probably she reached for her throat in an effort to try to slow the blood loss. You get a cut, you put pressure on it, and then eventually it will congeal and stop. That's his view of what Libby was probably trying to do. Said it could slow blood loss, again with the estimate, probably 5 to 10 minutes, but probably closer to 5. Libby also had mild cerebral edema, and Abby did not have that. It was only Libby. And so he was asked about that and what some of the causes could be and stuff. So it can be caused by loss of oxygen, loss of blood pressure, like by strangulation. Strangulation will often cut off the source of blood to the brain. That can result in swelling to the brain. You can get cerebral edema from a closed head injury. There's like a few different causes of it. What was significant for him was that it would take a few minutes for that to develop. It would take time for that to develop. So once again, we don't have an instantaneous process. It sounded like he was suggesting possibly, I hate to say this because it's horrifying, but the implication was that Libby would have been trying to hold her wounds together so hard that she may have cut off cut off some of the blood flow to her brain and cause this edema. He concluded his direct by just noting that you really can't determine a time of death with any kind of precision, and that they were consistent, that their condition was consistent with death occurring 40 to 41 hours before. That was a suggestion that he got from Mr. Luttrell. He said, yeah, it's consistent with that. Maybe it's consistent with other times too, you know, a different range of times. We didn't get follow-up on that. So Mr. Rosie came out firing, hit him right off with 98% of the time. He works for the state. He has opportunities. This was something I had wondered about previously, the process for a deposition in Indiana, because Judge Gohl had gotten snappy at Mr. Baldwin about the timing of submitting a deposition as part of his offer of proof. The deposition had been taken back at the end of August. She's like, well, couldn't you have filed this earlier? Mr. Baldwin's like, no. Well, so one of the issues that can complicate the timing of a deposition is that the witness in Indiana, it's the same process basically that we have in Washington. They are given an opportunity to be able to review the deposition, make changes to it, and then sign off. So he had that opportunity. He didn't make any changes. So he conceded he did not know, starting with Abby, when she died. In his deposition, the best he could do was that it was sometime between the last time she was seen alive and when she was discovered. Thanks, Sherlock. Couldn't have figured that out on our own. We needed an expert for that. But had accepted a range of 24 to 48 hours before they had been discovered. Said it can be very difficult to investigate the time of death. So I think we know that. I think that's consistent with what we've heard. Certainly, we didn't hear anything about, you know, again, efforts to take the internal body temperature, do the liver probe, even do like a rectal thermometer. We'd heard from the CSI guy that they don't do things like that with a sexual assault case because there's a risk of contamination. So I suppose it's possible that at this point in time, it's just too late for there to be any meaningful information. Like they would have just reached room temperature or cooler temperature or whatever. And so there wouldn't be viable information that they could get from that. But we also didn't hear anything about stomach contents, you know. We heard that very slight bit about the livor mortis being fixed within roughly 8 hours. So that gives us a little bit of a time frame, but just not a whole lot. Not a whole lot. He didn't tell us much about, you know, rigor mortis. We heard from the CSI guy that it had set in at the scene. So we have just only a very little bit of information to be able to draw those kinds of inferences. It doesn't sound like they really tried to determine or to reach an opinion about the cause of the time of death. They just sort of concluded it's not, we can't do it precise enough, so we're not going to bother. In the deposition, he acknowledged he had seen crime scene photos, but he wasn't able to draw any conclusions about time of death or anything from those photos. He could not say much about the type of the instrument that had been used. He could say that it was sharp-bladed, but as far as like a knife versus a scalpel, he wasn't able to say. He couldn't draw any conclusions about the length. He had said it could be anything from a pocket knife to a kitchen knife, and Mr. Rosie was very angry. And you didn't mention a box cutter, did ya? No, he did not. He could not say if the perpetrator was right-handed or left-handed. There's too many variables that would go in that. With is the wound inflicted from behind? Is it inflicted from the front? You know, what's the direction of the movement? All that type of thing. We did get the impression from Abby if it was a right to left drawing motion like he described, then that would suggest if, person behind, it would be using the left hand to do that on the left hand side of the throat. That seems to be fairly logical, but he did not make any kinds of inferences about that. With Libby, it just seems a lot harder to say because the wounds were vertical. They were vertically oriented and not horizontal like Abby's was. He agreed death was not instantaneous. There would have been several minutes potentially before unconsciousness in Abby. He had estimated in the deposition 4, 6, maybe 10 minutes. Because of that, she may have been able to react. She may have been able to make noise. She may have been able to move around. Her trachea was not damaged, so airflow was not restricted. This was, again, this is really, it's horrifying information. It's hard to hear. I don't like thinking about it. The reason why the defense is bringing it up, one, just because of the opportunity to raise an alert, raise the alarm. The whole concept, the whole theory here is that the girls would have kept, quiet as mouses because they were scared of the gun. The gun kept them under control. Well, once you've had a lethal blow inflicted on you, that incentive to stay quiet, that's probably gone. Now that said, there's going to be shock, not just like the medical, formal medical world of shock, but just psychologically, I would think you're just not gonna believe. You're not gonna believe what's happened, and so you're not gonna be thinking logically in that moment. So I don't know that that's really great evidence one way or the other about, were they killed there at the scene. That's clearly where the defense is going with it. What I took from it, though, was a little bit different. It went back to how the condition of Abby's body was so clean. It was so clean and pristine, and the sharp contrast between Libby, who had the blood on her hands, and they described that, even though Libby would have reached unconsciousness and death faster. Abby, this would have been a slower process. You would think she would have, moved, made gestures, blood would have dripped. There just would have been more of that, but there wasn't. And so it's very peculiar. It has raised the question in my mind, was she washed? And does that explain why the clothes were wet? Not that the girls went across the creek, but she was washed and then she was reclothed while she's still wet. It's possible. Just really put it in my mind, hearing about how this process went and trying to reconcile that with the condition of the girls when they were found. Confirmed the mark on the bottom of her mouth, whatever was there, wouldn't have restricted her breathing if it didn't cover her mouth. He says it's possible something was put in her mouth, but that would be speculative. Confirmed he could not get scrapings from her fingernails because they were so short. No trauma to her sex organs, but no opinion on whether there was in fact any sexual activity before death. So then Libby, similarly, the 4 to 5 injuries, couldn't tell if it's a right or left-handed person. There's too many variables. At the deposition, of course, he had indicated they were serrated marks and that possibly 2, 3, or 4 weapons could have been used, but there was only one of these wounds with these marks. The doctor suggested, well, that could just be affected by the angle or the force of the insertion. What he seems to be saying, if he's suggesting that there are marks on the handle of the weapon, that it basically, like, there would be a cut and then forceful if it's a forceful cut, then the handle would like strike it with some force. It would cause these abrasions. It would leave these marks. That to me, it just didn't seem to line up with the way that the marks were oriented to the wound itself. They were right next to it. The handle is below the blade. And so you would think if the blade is making an incision, the marks would be below that, because these were not deep. Remember, this was not deep. The jugular vein is not deep in the body. He said it's, I think, like maybe a quarter inch below the surface. And it was not cut all the way through in Abby. It was just cut part of, or wait, I'm sorry. Now I'm talking about Abby. Maybe an inch deep. So, I mean, I guess it could be a 1-inch blade with a handle. Could that be consistent with a box cutter? Yeah, okay. Yeah, I guess it could. My point is just that I would otherwise expect the marks to be below the point of the blade, and not like adjacent to it. The cerebral edema, he clarified it's likely from the oxygen flow to the brain being cut off while in this process of bleeding out, that it takes time for it to develop, and it was mild, but it does indicate that death was not instantaneous. In his deposition, he had estimated 3, 10, maybe 20 minutes as the time that it would take to lead to death, but didn't specify the breakdown between death and unconsciousness. So he also confirmed that the injuries to the artery could cause projection of blood. This is the arterial spray that you hear about. He estimated up to about 6 feet that would be possible. The debris on the leg, he agreed it was possible that indicated she had been dragged from another location. They addressed the sheet. He said that the sheet is often in the body bag. It's not used all the time. It can be reused, but there are concerns about contamination. So sometimes these sheets come from the hospital. He suggested that there are more sterilization practices going on there that would result to it, but he ultimately did not know what the source of the sheet was. He again emphasized that these were not classic serrations. It was just the best matchup he had come up with at the time that he wrote his initial autopsy report, and that afterwards he considered other causes. And this was where Mr. Rosie was kind of confronting him about, you didn't file a supplemental report, you didn't say anything about this in your deposition. Clarified, you talked to the prosecutor several times between the deposition that took place in February and now. Yes, he did. But at no point did he talk to the defense. He didn't raise any of this to the defense. Mr. Rosie is clearly not happy about this at all. There's no way to tell, conceded, no way to tell if it's a box cutter that caused the wound. He says that maybe 10% of the time he'll change his mind after the deposition about some detail. That seems like a lot. That makes it sound like his autopsy report isn't necessarily all that reliable. If it's something that one in 10 times, it's not right, and he's going to revise it after the fact. That seems like not a good position for him to be taking, but that is what he said, approximately about 10% of the time. Mr. Rosie then was eliciting that he knew this was a high-profile case. He had, in fact, met with a reporter at some point, had coffee with a reporter and chatted about the case, knew that it had gotten attention. And he got the doctor to concede that the report is for the definitive information. What he is talking about with the box cutter is more like speculation. We then went to redirect by Mr. Luttrell, who just asked what was the minimum number of knives that would be needed to cause all of these wounds. And he said one. So possible that one knife caused all of the wounds. Asked if the artifact that was next to the wound indicated that it was probably more than one instrument. And he said no. The jury had no questions for Dr. Kaur. I had a question for Dr. Kaur that nobody asked. And my question for Dr. Kaur would have been, did he learn at some point, perhaps during these series of meetings with the prosecutor between February and the time of trial, that Richard Allen had allegedly confessed to using a box cutter to kill the girls? I think it would be rather important to know if he had that piece of information, because that would suggest he tailored his testimony to fit it. That this was not just oh, I happened to see a box cutter in my garage and thought of it spontaneously. It frankly doesn't seem like as good of an explanation as just an atypical serrated blade. A serrated blade could have a part that's broken. The cut could have been performed, not with the tip, like with a different, perhaps a different part of the blade than he would expect to see. If it otherwise looks like a serrated marking, which it does. I mean, you can see in the photos, it really does kind of look like that. It's got this scalloped sort of effect to it. It's just problematic, this late in the day changing, and it's coincidentally to the same thing that Richard Allen has allegedly confessed to using. I don't know how it's going to sit with the jury. I found it quite suspicious, but as we've established, I am by nature a very skeptical person, so that did not sit well with me. We had our lunch. As I mentioned, we are now able to bring food and drink into the courthouse. We simply may not consume it in the courtroom. So I did get to have some lunch today, got to have some water. Things are going much better in that sense. I think we're all getting a little bit used to the routine. And having that angel from heaven descend into the line for me this morning certainly made a big difference. Somebody had asked yesterday in the super chats about how Rick is holding up, and so today after lunch I did notice I saw him smiling and talking, and he does appear much more relaxed. So don't know. Does he have a perception that things are going well? Is he just decompressing, continuing to decompress from his time in prison like we talked about yesterday? Hard to say, but he seemed to be in good spirits. So that is a little bit more information in response to that question. After lunch, we just had one witness. He went on for quite some time. This was Christopher Cecil. He's a Marine guy, and he has a very formal militaristic bearing. And one of the things that stood out to me is that, in these militaristic, like hierarchical kinds of structures, rank is very important. Rank is very important. And so Christopher Cecil was first sergeant, not sergeant, first sergeant. Wrote that down, underlined, make sure we know he's first sergeant Christopher Cecil. So he is another computer forensics guy with the Idaho State Police. In 2019, the Idaho State Police got a new piece of equipment called a gray key. And what gray key does is it allows law enforcement to access encrypted information from Apple devices. So those of you with Apple devices who are relying on the encryption to keep your information secure, sounds like it's not. They have these devices now that allow them to access encrypted information. So they got this new piece of equipment. He went through the training for how to work with it, and based on that, he then volunteered to re-examine Libby's iPhone. So he did a full file system extraction with the gray key, and then what that does, it gives him everything, all the entire contents of the Apple device, and so it was more than the prior. According to this got inconsistent a bit in the testimony. I'll cover that a little bit. He said it gives them more than the prior programs would enable them to be able to extract. So he got that raw data, and then he ran that raw data through the Celebrite or through the magnet in order to process and parse it. And then he did an individual exam to go through the contents basically and produce his reports based on what he found in his examination. It took him a while to do this analysis. He spent about 2 months on it between June and August of 2019. He ran it through both Magnet and Celebrite to try to make sure that he got all of the available information and did his analysis based on both of those analyses. He knew that Libby had recorded the video of the suspected abductor back in February 13th of 2017. So he focused his analysis on that day. And he was trying to use the phone to establish a sequence of events, to see what the phone data would be able to tell him about the events of that day. So we saw his first report. His first report was admitted into evidence. Once again, these reports being in evidence, I don't get it, but they are. And the defense doesn't seem to mind. They stipulated to them being admitted. So I guess it's okay. And so we worked through what was contained in that report. The report confirmed 2 people, Libby and Abby, had both been users of this phone. They both had user accounts for different apps and programs. There was biometric data. Touch ID was enabled, and there were 3 biometric fingerprints saved. We don't know exactly whose. But that was in there. That gave me that flashback. Remember what Mr. Baldwin said in the opening about human hands? I wonder what that might be referring to. Through this extraction, he gets Apple Health ID. So this is what gives you the steps, the distance, and elevation changes. If you watch the Karen Reed trial, you certainly heard about this, about the Apple Health information. This is based on information that's aggregated from all kinds of different programs and apps. And then it's constantly running in the background, and Apple is synthesizing that information into this health data. So it has an internal accelerometer and a gyrometer, and it uses that to calculate steps and elevation. It will also track the start and the stop times when the movements occurred. So based on that, he was able to make certain notations about the time period that we are all interested in, the time period on the bridge. So from about 1:30 to about 2:08 in the afternoon, the Apple Health data noted 1,682 steps. Between 2:08 in the afternoon and 2:18 in the afternoon, this would include the time period when Libby had video recorded, that down the hill video. It recorded traveling 414.38 meters. So not quite half a kilometer over that distance. From 2:31 to approximately 2:32 p.m., the Apple Health data showed a movement equivalent to 2 flights of stairs, an elevation change. It did not indicate whether it went up or whether it went down. And then the 2:32 was the last record of movement of the phone, the steps, basically, last record of any kind of steps taken with the phone. He emphasized if they had started walking later and had the phones, that it would have registered later movement based on that. But he did suggest that the phone could detect movement if it's not a step, if it's in a car and there is a bump or a bounce, that could register movement in the phone. He turned then to the knowledge C database analysis. Remember this from yesterday. This was a big thing for me. I'm like, why don't you go back and run, take this extraction that you said had the knowledge C stuff in it and run it through your updated program. So that is, in fact, what they ultimately did. He describes the background a little bit of the knowledge C database. He describes it as a volatile database, meaning the information does not stay on it very long. And it's not something that you're typically aware that the phone is logging. And so the type of data that it's tracking are things like when the phone is locked, when it's unlocked, when the screen light is on, when the screen light is off, that type of sort of use-related data. They had a whole list of not inclusive, like not exclusive, like a total list, not an exhaustive list, but a fairly large list of some of the data that this knowledge C database will track. I couldn't write all of it down, couldn't quite see all of it on the screen, but those are some of the things that I got. So he indicated that it was in 2019 that he learned of the existence of the knowledge C database. That this was basically, this was unknown in the forensic community. What happens is that the programmers for Apple, they aren't out there telling the forensic examiners, here's what's in the phone and here's how you get to it. They're not given instructions. They're reverse engineering. They're getting the phones. They're figuring out what's on there. And so the knowledge C database was the situation where the data is there, but they just didn't know. They didn't see it. They didn't recognize it. They didn't realize exactly what it was. So before the gray key, his testimony was that, before gray key, they would use Celebrite for these extractions, and that did not grab the knowledge C database information. So that would be why they wouldn't use one of the original extractions. That's why they needed the gray key to pull the phone again in 2019 and then run it back through Celebrite. Other things that it tracks, the app activities, device logs. So he created a timeline based on the knowledge C database information that he was able to get out of the phone. So at 1:38, there was a phone call made. The phone was charging. There was Snapchat being used. At 1:41, there was a Snapchat picture that was posted. He was able to find the corresponding picture inside the Snapchat application. That was a question we had from the other day. The picture of Abby on the bridge was not in the camera roll. So the question was, could it have been stored in the Snapchat database? That examiner didn't know the answer to that. So this particular picture he was able to find within the Snapchat application. At 1:43:59, there's another Snapchat picture posted. This is the one that was the first exhibit from the state, the photograph, the selfie taken in the car that Libby took and shows Abby sitting in the back seat behind. At 2:05:10, there is a Snapchat picture that is uploaded. That is the photograph of the plane photograph of the Monon High Bridge. He was able to find that on the phone. At 2:07:20 is the last time the phone was unlocked. Now, he doesn't note on this timeline when the photo of Abby was posted. We're going to get to this. There's questions about that. So at 2:07:20 was the last time the phone was unlocked. 2:13:51 is when the video was recorded of Abby walking across the bridge with the person behind her. He said it's a 43-second video. Really didn't seem like that, but I'll trust him that it was. And so at 2:14:41, somebody tries to biometrically unlock the phone, but apparently is not successful, and I don't think we have information about who that was. 2:32:39 is the last recorded movement in the Apple Health data. He is calling this movement of the phone, but that is not accurate. If the phone moves and it's not in a step, like if the phone is in my car and somebody is driving my car, the phone is not going to register steps. He did get to that in cross-examination, but I just pointed that out because he's using this language, last recorded movement of the phone. No, it's not the phone movement that's being recorded, it's the steps that are being recorded. So no steps recorded after 2:32, 2:39. And then at 10:32:36 is because, remember, he only did this for one day. He only did the February 13th analysis. So at 10:32:36, this was, according to him, the last recorded data from the iPhone. And because of that, he thought the battery was depleted. But he now knows that that is incorrect. So he gave his report to the investigators. After that, programs continue to be developed, they continue to be updated, and more data can be extracted, more and more data can be analyzed. There were updates to Celebrate and Magnet that allow more info to be able to be analyzed and decoded. So at this point, then what he did is he went back to those original extractions and then he reprocessed them through the updated version of Celebrate. So he did not do a new extraction for this part of his examination. He says he did not compare the 2017 data to the 2019 data, like to see if those extractions got the same thing. He had previously, earlier in his testimony, however, said that the whole point of the gray key extraction is that it can pull more than what those original ones do. But he says he didn't compare them. There was an interesting thing that was happening during this questioning. Mr. McLeland was handling the direct examination. He would ask a question that would be kind of a technical question. And on occasion, the witness would say, "Can you rephrase that? Can you rephrase that?" He didn't want to answer the question the way it was asked. And there could be different reasons for that. Typically, if it's a bad question, you just would clarify, I feel like most witnesses, you would just clarify, is this what you're trying to get at? Okay, I'll answer that. I will just tell you the impression I got is that they were trying to make sure that the testimony was very specific and that the ultimate impression that I got was that they wanted to suggest that the 2017 extraction, the data that came from that, and then the 2019 extraction that he did, that they both pulled the same data. And so that would tend to minimize the suggestion that had been raised in the previous examiner's cross-exam that the way that he handled the phone could have resulted in a loss of some of the data, because that then would show up, right? There would be more data on the 2019 extraction than there would be on the 2017 extraction. So there was a lot of care and wordsmithing of these questions to kind of avoid certain explicit questions being asked, like straight up, was the amount of data the same? Could you rephrase that? That, I thought, it made me uncomfortable a little bit. So then in 2024, he took his first extraction that he did in 2017, the one that Bunner did, and he reviewed it. He reviewed the timeline. He knew that Bunner had connected it to the cell network. And so as a result of that, there would be additional data in the new extraction that was not there on the February 15th extraction. This again was like they're really skirting around the comparison of the data between these two. And so he didn't compare them, but it's like probably deliberate that he didn't compare them. He says that the connecting to the network would not have affected the data that was previously collected, the method 1 collection, the very first one that he did. He connected to the network after that, so that would not have affected the first extraction. He was clear about that. But then at one point in here, he did say they compared the information gathered between the extractions and they were the same. This is going to come back up in cross-examination. So he previously said, no, I didn't compare them. But then just a few minutes later, he says, I compared them and they were the same. So then he did another detailed analysis between May and August of 2024. So this was all continuing to occur very recently. And then he wrote a second report in August of 2024. In that report, the first thing he did is he corrected some of the previous data. He had made a few typos about times. He had indicated that the phone had been unlocked by Celebrite when in fact law enforcement had provided the passcode. So the phone did not need to be broken. It was opened with the passcode. And then he had made an incorrect notation about the time of the last activity on February the 13th. So, relatively minor things, but he did start that report by making the corrections. So now we go back to Knowledge C and the Knowledge C database. He said that it usually retains about a month worth of records of data. Some information is stored for weeks, some information is stored for months, some information is stored longer. It just depends on what events the Knowledge C is tracking. And so whenever the phone wants to delete that old data, it will overwrite it with the new information. And it's on a first in, first out system. So that means the oldest stuff is the first to be deleted and then overwritten. He clarified that to kind of illustrate what it is that the Knowledge C database is doing. Pictures and videos, for example, are not stored in the Knowledge C database, but what the Knowledge C database does store is information about the use of the camera. And so it will indicate the camera was used, but it doesn't store the content, the product of that use of the camera. So because of that, the Knowledge C database, it can lose information. It is volatile like he described, and that occurs when the phone is powered on and powered off. He indicated that internet cached information is what will be deleted, whereas user created data will stay. So if you are personally doing something with your phone, you're entering a contact, you're taking a photograph, you are setting your alarm, like those end products will not be subject to the Knowledge C database. They won't be deleted. it's the information about the usage, and then the internet cached data. He didn't clarify like exactly what that means. But that's just the distinction that he drew. He also indicated that the health app data, that is not a part of the Knowledge C database. So in this new analysis that he did not get any new information from the Apple Health data. He confirmed that the way that iPhone calculates the steps, that in a controlled environment, they are pretty accurate. Over long distances of time, though, it becomes a little bit less accurate, and it would tend to overestimate the distances. I think we are on Ms. Auger's cross-examination now. I forgot to write down her. I usually write her name in the. Yeah, I did. I usually write her name in the margin to let me know that that's what happened, but I forgot to do that here. So we are in cross-examination now. Here's what caught it for me. She's the one that's drawing out all this information. So when he testified in his direct examination that sometimes if the phone is in a car and the car hits a bump, it will register movement. That, according to Ms. Auger, it apparently derives from a study that was done where one time, sometimes an iPhone would mistake hitting a speed bump for a step. So he conceded that. And so she was making the point that this is not just any movement. It didn't account for potholes. It's not accounting for climbing the hill, like you remember from Karen Reed, stuff like that. It's very specifically a study about a speed bump, and that it is only sometimes that would register incorrectly. The health data doesn't give location data, but the other apps do. And if you've allowed access to the location data on your phone. So on Libby's phone, she had location services enabled for a variety of apps. So you can enable it for sometimes while you're using the app. You can have it always enabled. You can have it never enabled. There were several that were enabled while she was using the app: the camera, the maps, the Snapchat, the App Store, Siri. It was always enabled for the weather app. It was never enabled for Walmart. I thought, this is really a girl after my own heart. So to get the location data, it's because the phone is connecting with a GPS network or with cell towers or with Wi-Fi. He confirms that CPS is very good accuracy. It's very high accuracy. During this cross-examination, I want to emphasize part of how this went, because there was a big misstep from my perspective, a major defense misstep in this cross-examination. So initially, Ms. Auger, she is really making points. She knows what she's talking about. He's agreeing with everything that she said. And something that one of the other, Julie Melvin, I was speaking to her a few times today, she noticed that sometimes when the defense is cross-examining the witnesses, they start to speak much more quietly. And I hadn't noticed this. I hadn't noticed this with any of the prior witnesses. She had pointed it out to me earlier in the day. With this witness, now noticed it. He's gotten real quiet. He's gotten real quiet. There's only a couple times that Mr. McLeland objects. When he objects, he is also real quiet. They've gotten quiet. Ms. Auger, she is making hay with this cross-examination. So she's getting good information out. So the video, she points out the location data starts near the Delphi High School. as the video records. And then as it progresses within 4 seconds, the data then came back to the trail, and that it was he claimed it was accurate to within about 30 meters at that point. So it sounds like they got additional location data through this subsequent extraction, that the first or analysis, that the first time they extracted it with the tools at the time when the analyst mapped it and just got like the whole town of Delphi. This new analysis was able to show that actually that did go down to more precise, more pinpointed, and it was within about 30 meters, about 30-meter accuracy. And he described the way that happens. So what happens is that when you first open the app or open the phone or just whatever is triggering the location data to be pulled, the phone is programmed to default to what is going to preserve the battery, and to use what is going to preserve the battery, like when possible. And so that's what it first uses when it opens, and those are going to be likely cell tower data. And the cell tower data is what is, like we've been talking about here, not particularly precise if you're just connecting to a single phone or to a single tower. So then as time passes, it will start to use more battery to perform this function, and that's then when it will start to use these satellite-based systems to get more detailed information as the time goes on and as the video progresses. Liberty had location services on for Snapchat. And so the Knowledge C database shows when it's being used. The location services should have gotten it within about a 5-meter range. It doesn't map continuously. None of these apps will map continuously because that would drain the battery. So the app has to be open for the mapping to take place. But the Snapchat location services seems to be a fairly precise location information. He did say that having the battery low, like if the battery goes low or if it's trying to save the battery, that would not interfere with the Apple Health data. So based on the new information, they conclude that the phone, he had previously thought it went off at 10:30 because the battery was low. No, the new conclusion is the phone stayed on until sometime after 4:30 a.m. the following day. And the reason why is because at that time, the phone suddenly received a bunch of SMS messages. And there was no indication that the phone was turned off, nothing in the log that would indicate that the phone was turned off. And, but there was no movement that was tracked in the phone up to that point, that, 4:32 a.m. when the SMS messages came flooding in. So they kind of modified the timeline after the phone stopped moving at 2:33 p.m. So he said the phone is receiving calls, SMS, and he clarifies what SMS is it's a message that's sent solely over the cell network, not over the information, the data network, satellite-based and stuff. So it's just calls and texts and things like that can typically go by either network, but SMS is specifically only over the cell network. So during this time frame, the phone is receiving calls, it's receiving SMS, it's receiving texts. At 4:06 p.m., it receives an SMS from Becky Patty. You need to call me now, with exclamations, several exclamation points. And that there's more after that. It's noting, this information is noting the fact of the communication, but not the detail, not the text detail or the call detail or anything like that. It will show the name of the contact if that person is saved on the phone. And so then those messages continued to February 14th. And then again, several came in at 4:38 a.m., about 15 to 20 all at once. She asked him if he knew why all of these SMS messages came in all at once at 4:38 or 4:33 a.m. He doesn't know. He doesn't know why. He doesn't have an answer or an explanation. On February 14th at 4:34 a.m., he says that's the last operating system activity, and they are not sure what happens after that. So there doesn't seem to be a record of what happened to the phone. It's on February 15th, the following day at about 7 p.m. that the iPhone then is booting up. That's when Bunner had turned it on and plugged it in and charged it for his extraction. So at some point before that, the phone had lost power, but there is not a record of that. You know what? I think maybe I was wrong. I think maybe this was not cross yet. The reason why I say that is because I think it wasn't. I thought we were because of that concession about the speed bump, the study of the speed bump. Maybe he just specified that in his questioning, and Ms. Auger drew it out later in cross-examination. I think that is what happened. So I'm sorry, guys. I was right the first time. This has all been information that's elicited on direct. The reason why I know that is because at this point we went to recess, and when we came back from recess, Mr. McLeland asked for permission. He had passed the witness. So he was done with his questions. It's going to go to Ms. Auger. But then he came back after recess and told the court he asked for permission to ask omitted questions. He forgot to ask some things, so he wanted to follow up on that before she proceeded to her cross. So I apologize. I had it right the first time. This was all direct examination. So the omitted questions that he had wanted to ask on the first report, there had been some asterisks by some of the entries, and this was very important. He had the timeline for when the photo of Abby on the bridge was posted to Snapchat, but he was not able to find that picture on the phone, and he didn't know why. So he had found a picture on the internet of Abby on the bridge that had a timestamp that was the same, or roughly, I think, the same as the timestamp that was showing in the Knowledge C database for when that event had taken place. So that was introduced as an exhibit. It was just the one that he found on the internet to confirm that, yes, this was a photo and maybe corresponds with this timestamp that is there in the report. But he didn't find it in the phone, so it was not in the Snapchat database like the other photos, which is odd. He also clarified that the measurement for the elevation change that's used for this program is one flight of stairs is equivalent to approximately 10 feet in elevation, or 16 steps. So the 2 floors that were noted in this particular case on February 13th at the 2:33-ish time, was about 20 feet elevation change, but they did not know if it was elevation change up or elevation change down. And then he also said that on February 13th, between 12:01 p.m. and 1:31 p.m., there was no entry. And so according to him, that means the phone isn't moving. So now we go to Ms. Auger's cross-examination and the many, many points that she scored. And so we'll get back to some of these other things. So first thing she hits on this exhibit, the photo he got from the internet. It was just a random photo he got on the internet. She asked him, where'd you find it? He's like, I think I did a Google search. He doesn't remember what he searched for. The timestamp was, I think, on the I couldn't see exactly what they were talking about, but there is a timestamp of 2:07 that I believe is the information from the report. But then the time, I think, on the photo, like if it was screenshot or something, it says 7 hours ago. That, could mean anything. Nobody knows what that means. She then presented the defense exhibit A that's already been introduced. She represented it as being the original picture, and the original picture has no date or time stamp. So I don't know yet where exhibit A came from because they didn't find the original on the phone. So I don't know how this is the original. I don't know if there's been a defense analysis that maybe was able to recover some deleted data or something like that, and that's where it came from. It's not clear to me. So she just elicited that he doesn't know who put the 2:07 marking on that photo. It was just some random person out on the internet. And we don't know when the photo was actually posted, from looking at the photo. So she walked through the timeline of the Snapchat photos that 1:40 there was a photo taken. It was found in the Snapchat cache. At 1:41 a photo was taken. It was found in the Snapchat cache. 1:43 a photo was taken. It's found in the Snapchat cache. 2:05, these are all photos that are posted to Snapchat. It's found in the Snapchat cache, but he didn't find the one from 2:07, and it's also not on the camera roll. So it's an outlier. This picture of Abby, it's gone. It's quite curious. So she asked one possible explanation. Could it have been posted to her account from another device? He said possibly. Possibly could have done that. I'm not sure what that's implying. At 2:07, Bridge Guy is still not there. Maybe she's suggesting there's more than one person that took the photo and put Libby's Snapchat information in their phone and then uploaded the photo to Libby's account. That seems to kind of be what's implied. It seems far-fetched to me. It seems far-fetched to me. To me, it seems like a more logical explanation is someone somewhere somehow deleted that photo. Don't know how. They agree Abby's in the same clothes as she was in that day on the 13th. It looks like it's the same time and place, so it doesn't look like it's a situation where, a photo gets posted to Snapchat and it's like some old photo. Really does. It appears to be time and place accurate. Just can't really track down where it is. So if it had been, you can post things. They asked if you can post things that you upload to Snapchat. He says, yeah, you can, but it would still be on the phone. You would find it somewhere on the phone. So he conceded that the cell phone data, it's accurate, it's reliable, including the Apple Health data and including the Knowledge C database. These are hard sources of data, is clearly what the defense wants to establish. She asked him about an encrypted cache. He did not know what this was. He said he wasn't aware of an encrypted cache. She asked him about what's called an UFED, which is an acronym for a Universal Forensic Extraction Device. She says that it has been around since 2007. She asked him, she's like, and this allows for a physical extraction. He first says, no, it does not. But then he stopped and said, well, it could, but it depends on the make and model of the phone. Whether that was going to be available before 2017. So this is hearkening back to the first extraction that the first analyst did, was the logical extraction, which is very basic. And so she's just kind of pointing out or suggesting there could have been a much more thorough extraction done back in early 2017. So we got a little bit more description with this analyst of those different levels of extraction. We heard about the methods, the method 1, method 2, method 3, and how method 2 and method 3 didn't become available until later. But so we got a little bit more, we didn't hear more about that, but we got more of a breakdown of what the logical, the advanced logical, and the full file system extractions are. And so the logical, he describes as typically what the user can see. So it's just the visible data on the phone, the things that you would be interacting with, that you would have knowledge of. The advanced logical, he said it's typically like an iPhone backup is what that's going after. It gets you just a little bit more than the logical extraction. And then the full file system is what she described as the data under the hood. So it's the system files, it's logs, it's the Knowledge C database, all of this stuff. This is where they drew out how Apple doesn't tell the forensic people what's in the phone. They have to figure it out and how to get to it. And so that's why the Knowledge C database was unknown. She asked if he was familiar with a power off log. He was, although he referred to it as a shutdown log. He acknowledged that the shutdown log is volatile and that every time you power the phone, it overwrites that log. And so when Bunner powered off the phone, it would reset the log. And so because of that, that's why we don't have access to what time the phone was shut off back on February 14th. After it came alive at 4 something in the morning and received all of the SMS messages. At some point it powered off because Bunner had to power it back on to do the extraction, but there's no log of it, and we won't be able to find out when because it's been overwritten. Two iPhones, she confirmed, again, we revisited this, they can use iMessaging, which is the encrypted message service that Apple provides to its users. And it uses SMS communications with Androids. And so those don't use data, those just use the cell network. So when an iPhone talks with an Apple, they are using SMS. So she clarifies then the phone, it received no calls or SMS messages between 4:06 p.m. on the 13th and 4:33 a.m. on the 14th. He had said previously that it received some iMessages throughout the night. But at 4:33, the distinction is that the SMS messages need the tower. And so at 4:33, it received 15 SMS messages, and he did not know why. So Ms. Auger used what I think is a fairly commonplace example, a relatable type of example of if you go to an area where your phone is out of service and then you go back to where it's in service and the phone reconnects, all of these things will pop up on the phone. And does that happen? She asked him, does that happen to you? Yeah, that's happened to him. So that's clearly what she wants to imply is the reason for the SMS messages suddenly coming in at 4:33 a.m. is because that would be when the phone reconnected with the network. Everything else that went through is able to use the data system. Most messages are, the SMS messages are time stamped at the time of receipt. So it's not until they actually land in the phone that they get time stamped. So all of those 15 to 20 or whatever that come in, they would be time stamped at the time of receipt. iMessages, by contrast, are time stamped at the time they are sent. So regardless of the time that they are received, it doesn't mean that the phone had power when those iMessages are time stamped. It doesn't mean that they are received. So the fact that it sounds like there are iMessages that are time stamped between the 4:06 p.m. and the 4:33 a.m., it doesn't mean that the phone had received them. And he conceded that point. He had had his deposition on September the 12th. In that, he acknowledges that the knowledge C database, it exists on the phone, it contains information, and that he had used all of the different extractions to prepare this very detailed 2017 report with the timeline. She introduced Exhibit P, which is basically the original source of all of the, it sounds like it's all of the knowledge C database. And then what he had done is he had gone through and selected the ones that seemed to be like pertinent, seemed to be most helpful for interpreting the timeline in terms of events in the real world. So that original was admitted into evidence, but we did not really follow up on that. And that leads me to think the stage is being set for something that is coming in the future. Same thing with the reference to the encrypted cache, which he didn't know about. It sounds like that's something that she knows about from another source, and so we will probably hear about that later. I'm filing that away for future reference. She confronted him on whether the phone would track the movement in a car, because he said he had gone and researched it and he'd found this white paper that said, you know, sometimes on the speed bump, that's it would record it. But you aren't able to know if it does or if it doesn't. He said the source is, first off, it's a preliminary research report, so it's not like a final, you know, thorough, peer-reviewed anything. It's some preliminary research that somebody has done. And it says that the iPhone sometimes mistakenly reports the speed bumps as steps. So not that it always does, or even that it predictably does, just that it's sometimes it has happened. But also that's limited. It seems to be limited to speed bumps. Maybe that's because of the elevation, and the elevation is kind of similar to, you know, what you would do in a step. I don't know. I don't have an explanation for it, but it's just based on speed bumps. Otherwise, remember, his earlier testimony was that the health app data is very accurate. It's accurate and reliable. She pulled out that the gray key can and did recover some deleted files. This was also just sort of left hanging out there. This is what made me get thinking about that photo. The photo of Abby on the bridge that we can't find anywhere, but somehow the defense has the original. Seems like it got deleted somehow. Don't know if it was intentional, don't know if it's inadvertent, don't know when or where or how. But that's the implication I got, that that's kind of the stage that's being set. They did, in fact, recover some deleted files. So didn't hear much about that from this expert. Think the stage is being set for whatever the defense has that they're going to bring. So she established again on February 23rd of 2017, Bunner conceded in his examination, he had connected the phone to a cell network, and she got this witness to agree that as a digital forensic analyst, that is typically a no-no because there's other ways that you can get cloud information, and that can, again, it can just cause, it can cause problems with loss of data to be overwritten, things to be, you know, not what you want. She also elicited from him that you want to get everything the first time you do an extraction, because every time you plug it in, you're potentially losing data. Plus, anytime the phone is powered on, you are potentially losing data over time. So there she is clearly getting at, you know, Bunner did an extraction, you know, did like 4 or 5 extractions that he described, like several ones over and over and over again. The implication is that every time you do this, you are potentially losing data in that phone. He agreed that with these analyses, it's helpful to have a second set of eyes, and that in 2019, the FBI requested the full file extraction that he had done, and that he had asked Mr. Holman, deputy, is he deputy? I don't know his formal title, Jerry Holman, if he could provide it. You can't ask him what Jerry Holman said because that would be hearsay. But so asked him what he did at that point, and his answer was he did not follow up. So he didn't give the FBI the new extraction. They didn't want the FBI looking at the new extraction. This is troubling. This is troubling. This is alarming. We just have heard over and over again, more information is better. More information is better in an investigation. That's going to get you closer to the truth, but you don't want to know what the FBI is going to tell you is on this phone. That's not good. Really not good. We had what really looked like a very strong moment here at the conclusion of the defense case. Ms. Auger got him to say, she confirmed that he had also extracted Richard Allen's devices. She went and stood next to Mr. Allen. She had her hand on his shoulder. And she says, nothing that you found ties Richard Allen to Liberty German. Nothing in those devices ties him to Abby Williams. And nothing that you found in those devices tied him to this murder. And he agreed with all of those propositions. Nothing in the extractions of Richard Allen's devices tied him to that. This was very powerful. Unfortunately, it went very south when Mr. McLeland got up on his redirect. So the first thing he addressed is that he confirmed data is lost when the phone is turned on and off. Not only revisited the issue of the 2017 and the 2019 extractions. Remember, we had that discrepancy between didn't compare them, but they matched, but they didn't match, right? They're kind of all over the place with this. Didn't compare them, they didn't match, but then they did match. So he clarifies now at this point that it was only the user created content that he got from Bunner's extraction, because that's what you get from the logical file extraction. So all of that stuff matched, right? But his extraction is going to have a lot more. So, yeah, he got the same stuff out that Bunner had originally gotten out in that first extraction, but it doesn't speak to, like, does that mean stuff didn't get deleted then, or whatever? So whatever implication they were trying to draw, like to suggest everything you got it was all fine what they did back in 2017 because the data matched what you got in 2019. No, they're just saying this was limited data that you got in 2017 and that was still there in 2019. The stuff we pulled in 2019, we already heard from him from Gray Key. It's pulling much more information, and you're able to parse more information from that. So it's not like a one-to-one match. It's a very limited stuff that matched. And the use of the phone data that's held in the Knowledge C database, that is only available in the 2019 extraction. So no way to tell what's not there because it was never there in 2017 in the first place. So he confirmed that the phone was not shut down until sometime after 4:33 a.m. on February the 14th. But of course, we don't know when. And there's no movement recorded again after 2:33 p.m. on February 13th. So no more steps recorded. Here's where things went very south. When Ms. Auger was asking that question about Richard Allen's extractions, I immediately thought, why isn't he objecting to it being beyond the scope? We've seen that happen before, right? He actually did it. He actually did it just before with some of the questions that she had asked, like when she was asking about, is it bad to, for an analyst to connect to the wireless, to the network, to the cellular network? Mr. McClelland had objected to that as beyond the scope, and she was saying, they talked about this on direct, and so it was overruled. So, he knows this objection. It's not like, oh, he's maybe not used to using that one, doesn't think about it or whatever. He had literally just used it, and she's switching gears to something that is clearly not what they had talked about on direct, this extraction of Richard Allen's devices. I had noticed that at the time. He's not objecting. Reminds me of, what is it, Napoleon? Is it Napoleon that said, never interrupt your enemy when he's in the middle of making a mistake? Oh, this is very devastating. So he elicited that they analyzed 23 devices that they got when they executed that search warrant at Richard Allen's home. They knew what the release dates were for all of his cell phones. So they had the individual identifiers for his devices. The IMEI or the NEID, I guess, is another one that they may use for cell phones. It's a unique identifier for all cell phones. So they had the IMEI for his cell phone in 2017, the one that he had then. They probably subpoenaed it from the carrier. Didn't say that explicitly, but I would suspect that's how they got it. Because they then compared that IMEI to the list of devices that they seized from the house, and the 2017 phone wasn't included in the analysis. They didn't find it in the house. That's where he ended. That's really devastating. Really devastating. Because one, you, the defense, really oversold your position. And now you look sketchy. Now you look shady. Now you look like you're trying to mislead the jury about what they knew. Of course, if you didn't have his 2017 devices, they wouldn't show any connection with Abby or Libby or with the murders. Of course they wouldn't show that. But when you have 23 devices that they analyzed, we don't know what those devices were. A device can be a lot of things. It can be a cell phone, but it can be a laptop. It can be an external hard drive. It can be a thumb drive. It can be a lot of different things that will store data. And now I think it's going to be really important that we know exactly what all 23 of those devices are, because if somebody just doesn't have their 2017 phone anymore in 2022 when he's arrested, and the search warrant is it's executed before he's arrested, but at that general time frame, that in and of itself I don't think is too unusual, right? Who keeps their old cell phone for 5 years, without updating it? I mean, I'm not going to say I never have, but I find it a pain to upgrade the phone. So, I probably suffer through an old outdated phone longer than I really should. Jeff can tell you I had a phone that I cracked the screen, and I so didn't want to go through the updating, the changing it over to the new phone, that I was using this cracked phone for, I don't know, months, many months. It drove him nuts. He hated it. Didn't really bother me that much. But so that's me with my cell phones. I'll hang on to one forever. But I think most people, it's really not uncommon. New model comes out, your old one is getting slow because it's, you've loaded it up with apps and stuff like that. You just get a new phone, you trade in the old one. In and of itself would not be that strange to not have the 2017 phone in 2022, but we need to know what all of these other devices are now, because if he had devices that were older than that, and it's like just the 2017 phone that's missing, holy cow, does that look bad? Is that incriminating or what? We need to know now. Big own goal by the defense, in my view, on that one. So Ms. Auger did do a very brief redirect. She clarified, yes, he had gotten the devices on November the 8th of 2022. That was just sort of where she left it. Yeah, it's 5 years after the murders. But you're the one who implied they would have had the 2017 phone when they did the extractions, because otherwise it's of course they didn't have any link with Richard Allen and the murders in Libby and Abbey. And then just reiterated that this after 2:32 p.m. when the phone stopped moving, or 2:33 p.m. when the phone stops moving on April 13th, that the Apple Health data records the steps, and so if it was in a car, it wouldn't necessarily record steps. So providing some evidence, some implication there supporting that defense theory that maybe there was a car down at the drive at the far end of the bridge that would have taken the girls away from the scene. And if that had happened, there wouldn't have been step data recorded. The defense has put a really big burden on itself with its own expert to support this theory now, in my mind, because they're putting these pieces together, right? Okay, no Apple Health data doesn't mean that the girls themselves didn't move. It just means they didn't walk. So they could have been transported by car. That's consistent with the defense theory. They could have been transported by the car out of the tower range. That would also be consistent with the defense theory. It went out of range, and then when it came back in, that's when the SMS messages flooded in. But if the phone is on this whole time, there's other sources of location data on that phone, and they better be able to show me some that moved. They better be able to show me the phone powered off and back on. They better be able to show me location data that moved. I mean, something that's going to corroborate that, because otherwise, it just seems like this absence of location data after 2:23 p.m. There's not a good explanation for it, right? I haven't heard an explanation for it, why that would be. Cell tower, sure, it could be you lost power, it could be that you went out of service, but you don't go out of service of the satellites. Satellites are always there. You know, there's always something that you can connect to. So if the phone was on, should be connected to satellite, and things that are using location services should be tracking location data. Haven't heard anything about that. It's strange. I'm going to want to hear about that from the defense if they want to substantiate a theory that the girls left. I suppose they can, you know, still hang on. Well, it's possible. And so if it's possible, it's a reasonable doubt. You know, it's consistent with the evidence. They don't have the burden of proof, of course. But this is I'm having a hard time reconciling this. And I feel like this was just such a major misstep with the jury. They made themselves unnecessarily look shady to score the point, and it was a strong point for the brief moment that it lasted. And once it came undone, now unfortunately I think the jury is not trusting the defense on the phone data. And so it's very unfortunate. Got all these concessions. The phone data is the hard data, it's the reliable stuff. But now I feel like they have kind of, by that move, assumed a burden on themselves to substantiate what they're saying. They can't be trusted to just have the implication. And it's very unfortunate. Very big own goal. Whole bunch of jury questions about the cell phone stuff, like 4 pages of jury questions, 3.5 pages of jury questions about the cell phone stuff. I tried to capture, I'm pretty sure I captured them. Hopefully I got most of the details. By the way, at this point in time, I was blessed. I had many blessings around me today. And one of those blessings was Lawyer Lee. I had 3 pens today. Okay. They all ran dry. So I had my pen that I came into court with. It ran dry. I had actually given Lawyer Lee one of my pens yesterday. She wanted to try it out. I was like, oh yeah, go ahead and take one and try it. She's like, ooh, nice pen, you know. And so she'd had my pen. And I was like, I'm so sorry, because this happened mid-morning before lunchtime. I was like, I'm so sorry. Can I get that pen back from you? My pen has gone dry. She very kindly gave me my pen back. So I used that pen, and it also went dry. It was like going dry before lunch. I'm sitting here shaking my pens, you know, to get as much ink down to the tip as I can. Let's just can we get to lunch? Because I got a pen in my car. I can run out to my car and get that pen. So I did. I ran out to my car and I got that pen and I brought it in and it started to go dry. So Lee kindly gave me one of her pens. Here's my pens. Here's Lee's pen. I got a Lee pen. It's actually quite a nice pen too. I really like it. It's this Sharpie S gel. It's black, nice black pen. It's got very nice movement with the writing. So anyway, thank you to Lawyer Lee for saving my skin with getting all of these jury questions. I would not have gotten them without her pen. I'm going to give her another one of my pens again tomorrow. So we got a fair trade there. So first jury question was in the first report, the picture of the Monon High Bridge at 2:05 with nobody in the image. Did you locate it? He said he did not. That, I thought he said that he did. This was when they went through the cross-examination, they very specifically walked through the pictures from the different time frames, and they had been posted by Snapchat. They said specifically the 2:05 one, it was found in the Snapchat cache. It was just the 2:07 one, which is the one of Abby on the bridge, that they weren't able to find. So he said he didn't locate it, but I don't think that's right, or I think maybe, I don't know. I can't explain his answer. He said no, but previously he had said yes. In the timeline on the first report, there were a whole bunch of blank spaces under the event section. It was like empty spaces. They asked what are those about? And he said it had to do with the battery levels. He was trying to track that separately from the other info, the battery info from the other information. So that's what these spaces were. When that exhibit is someday maybe ultimately made public and we're able to see that, then we'll have a better idea maybe of what that one is about. Auger then clarified, okay, this was it. Auger clarified that 205, he did not print that picture. So I think he did locate it. It was just that he didn't print it. So that was, I think, the discrepancy between those answers. Next question, how does a phone receive iMessages, calls, etc., but not SMS without a cell connection? And he said he had no answer for that. He doesn't have an answer for how a phone would be receiving iMessages, calls, etc., but not SMS without the cell tower connection. Yeah, I don't know. I don't know the answer to that either, because that data information is transmitted through the cell towers. That's not the satellite stuff. Is the location data stuff, but you're not running your data system by a satellite unless you got Starlink, and that's not what we're talking about. So that is peculiar. He doesn't know, because it seems like maybe the phone is connected to the network, but it also seems like maybe the phone is not connected to the network. He has no answer. I will be interested to see if there is a defense expert who has an answer. Question, did you check to see if AT&T had tower issues at that time? No. Ms. Auger clarified that he would not do that. Other investigators would do that. But we haven't heard anything about other investigators doing that. I wonder if they did. Maybe. I don't know. But that really does seem like that should be a really obvious follow-up. If there's sketchy stuff going on with connectivity, we would check the tower. I don't know if there's something going on in the tower that would affect the ability to get SMS, but not these other message types. No idea. Question, does Snapchat save photos that are not uploaded to the story? Answer, no. Ms. Auger said, but you'd expect uploaded photos to be there, I think, if they were uploaded, the stories, you'd expect them to be there, and that the answer is yes. Question, do pictures sent via Snapchat, not through the stories, but just through the other Snapchat function? I don't know if it's messages or just like some other, I don't know Snapchat, like I said. Do pictures sent the other way via Snapchat get saved? He did not know. Mr. McLeland asked if it's uploaded to the story, where is it saved? He didn't know. He speculated that the story photos would be saved in the cache, but he said that would be speculation. And Ms. Auger pointed out and confirmed that 3 of these photos had been saved in the Snapchat cache. Question, can iMessages be sent via cell service? Yes. And Ms. Auger again just confirmed they are time-stamped as of the time they are sent, not the time that they are received. So that could explain part of that discrepancy about not receiving iMessages. The iMessages, the timestamp would be, it wouldn't be accurate. If it came in at, the report would show it coming in with the timestamp of the time that it was sent, but that doesn't necessarily mean that the phone had received it. So it would not be that the phone had received calls and texts and iMessages and SMS messages, but not SMS messages during that time frame. We don't know if it received the iMessages. So then we're still left with calls and texts. I would love to know about their time stamping. Is it the same as the iMessages, or is it different? Do we know if the phone was actually receiving this stuff during that time frame, or is it just time stamped because it was being sent then? Question: how much data is lost if the phone is off for a month? He doesn't know. Question: is the month a period of 30 days between powering it on and off, or is it a calendar month? He did not know. This, I think, is just relating back to when he said some data is stored for weeks, some data is stored for months. What does that mean? What's a month? We don't know what a month is. Asked if the method 1 extraction garnish the knowledge C database. That information, so that original method 1 extraction, did that pull the knowledge C database? The answer was no, it did not. So that's why they needed to do that later extraction in 2019 with the gray key. Question: could the Snapchat photos be deleted in the knowledge C database without app usage? He didn't know but thought no. So Ms. Auger followed up that to just establish that the Snapchat photos are not stored in knowledge C. So no is probably the right answer. But you use, yeah, I mean, who knows? I guess, yeah, if they weren't in the answer to the question, if Snapchat photos aren't in the knowledge C database in the first place, then no, they can't be deleted off the database by anything at all. So it was just basically a question that is nonsensical in that sense. Question: could a picture not be added to the cache based on battery life? He said he does not think there is any relationship with the battery. He does not know if it's possible for a photo to not be saved to the Snapchat cache, or if that could be affected by user activity. Could the Snapchat cache photos not exist depending on how posted or whether they were not posted? He did not know the answer to that question. I think this is a similar issue with just the previous question about like how if they're stories, if they're used the regular, like how does this stuff get stored? He doesn't know the ins and outs of the Snapchat storage, and I guess he has not. Maybe nobody knows. I don't know. Maybe he hasn't bothered to know. I don't know the answer to that, but he doesn't know. Mr. McLeland again reconfirmed the 207 picture. It was not recovered, and he doesn't have an answer for why that one was not collected when the other ones were. He doesn't have an answer. Ms. Auger asked if confirmed that the Snapchat could be accessed from another device. Maybe that's the implication. It was deleted by another device. Really don't know. Question: does the app give us a start and end time for the 2 flights of stairs? This was a very good question, I thought, because it didn't have a specific time data associated with it. And so the answer was no. That was included in the other movement data, that basically while there were steps being recorded over a different time frame, the elevation change occurred during that point. So we don't have specific time data that's exactly, from the time of the start of the rise or the descent to the end point. Also, reconfirmed that we do not know if that data is up or down. Seems fairly logical to assume that it's down, consistent with the girls going down the hill. But it was just encapsulated in this time frame where he says there were 50.60 meters. That was the distance, and it occurred during that movement. Question: what happened to Apple Health data between 218 and 225? And he says the phone was not moving at that time. Again, I think he means there's no steps being taken at that time. 218 to 225, that's a fairly significant period of time of our abduction, right? And at some point in here, we're being trapped, we're crossing the river. Maybe this is where Mr. McLeland is going to piece together, like they had stopped because, you know, he's going to have his way with them, but gets interrupted. And so it's after that they cross the creek, and then the killing occurs. I still don't think we have enough time for everything that happened at that crime scene. And it just doesn't make sense still. It doesn't make sense. If you're in a hurry, why are you moving the bodies? I mean, they are clearly moved. This is not a situation in this crime scene, given where the blood pools are located and just the patterns and everything. Whether they, you know, whether they died there or not, I've expressed my skepticism. It doesn't seem like there's enough blood to me, but I am not an expert, and you know, yes, different things can affect it, how fast the soil flows. I mean, maybe it does. Maybe it just seeps into the soil. I don't know. But what I do know is that if you are going to, you know, kill somebody by cutting their throat, and you're in a hurry, right? You cut their throat, drop them on the ground or whatever, they die in place. The blood is going to just pool there and, you know, around. And then that's where that puddle will be. And that's where there will be the seepage. And that's not what we have at this crime scene. So at a bare minimum, we have what appears to be, you know, some movement of the bodies at the crime scene. And then these branches put on top of them that is not remotely concealing. It's just not remotely concealing. I don't know why we did that. If we're in a hurry, especially, I don't know why we're doing that. And that's even before we get to, you know, this very open question to me of was Abby, it seems like she was washed. It seems like she was bathed. She was so clean. She was so clean, especially those hands. And compared to the very bloody hands that Libby had, that the pathologist explained, this is probably the instinctive response to cover the wound. Abby's wound, she would not have died as fast. Seems even more likely, you know, she would have had it on her hands, but her hands are pristine. You're not washing her if you're in a hurry. So still a lot of problems with the state's theory for me, but this, I guess, could be part of their explanation. This is like a 7-minute pause, and it's after that maybe that he orders the girls across the creek. How did you determine that Richard Allen had no connection to Abby and Libby or murders from the phone data? And he said, there was no information on the phone about them, no interaction, no indication that he ever knew them. So this, I think, also like deflated that defense point quite a bit, because it wasn't that he was saying like there's the location data on the phone puts him somewhere else, or like we can't get location data on the phone that puts him anywhere near the bridge or anything like that. That hard, reliable data that the defense was so bullish on. It's not that. It's just that they didn't have proof of any kind of interaction or that they had known each other. Mr. McLeland elicits he did locate internet search history about them, about the girls. Ms. Auger then just clarified, though, this was after the murders had taken place. So not necessarily that incriminating. Probably lots of people in the area did internet searches about the girls after the murders had taken place. She also elicited that we don't know who performed that search. There's no way to track that. It's just a search that took place on the device, and we don't know who has access to the device and all that stuff. So, guys, that was the day. That's what we got. Like I said, a little over about right about 2/3 of a notepad. So not quite as much as in the past days, but still quite a bit of information. And so I hope you can see now how the day was very unsatisfying in the sense of, okay, we got some more answers. We got some more details that we didn't know about, but did that answer the deeper questions about the case? Not really. Not really. There is just still a lot of stuff that is open, that is really up in the air that we don't know. And I don't know if we're going to get those gaps filled in. I'm starting to doubt that. It's unfortunate because everybody wants answers. Everybody wants to know what happened to the girls real definitively. And I am just not real confident we're going to get that. I'm still not on the state's theory as far as the timeline goes. As far as just the mechanism and stuff goes, I'm not on the theory. I'm still not convinced that Richard Allen particularly fits the description of Bridge Guy. We had all of these commonalities in the descriptions of Bridge Guy. Average to tall height, young. Although that not so much, we didn't get that so much from Ms. Carbaugh today. She indicated that she had estimated the age to be older. So that's no longer like universal between all of them. But two of them, had indicated young. Or three of them had indicated young because Betsy Blair had said that also. And two of the four, thought he was muscular build. Oh, I mean, the defining, the very distinctive physical characteristic of Mr. Allen, if you're going to describe him, is that he's short. He's a short man, and that is not, what came up in any of these descriptions. So I'm not convinced he matches the description of Bridge Guy, but we also don't have him accounted for out at the bridge. And he acknowledges he was there. I mean, he puts himself there. And so this is tough stuff to put together, because if he wasn't Bridge Guy, but he's out there in the same general time frame, then how come nobody saw him? They saw all these other people, they saw each other, but they didn't see him. And he also, I believe, in his statement to the police, he acknowledged passing the girls, the three girls, the Voorhees girls and Bree Wilbur. Well, they only describe passing Bridge Guy, although Bree Wilbur was a little bit more. She was a little bit more loose as far as just saying they were passing people out there. Like, for example, she was saying that the reason why Bridge Guy stood out is because they were passing people on the trail, and Ms. Voorhees was saying hi, and everybody would say hi back because this is a small town, and that's just the kind of community it is. So maybe they did pass him and just didn't take any notice of him. Separate from Bridge Guy? I don't know. I just don't know. A lot of questions, guys. I still got a lot of questions. The more this case goes on, day 8. We're on day 8 here. And I almost feel like I have more questions now than when we started. I really do. I'm not sure what to make of this at this point. And I guess the thing to do then is to just continue to do what Mr. Baldwin has implored us to do and wait. I'll keep waiting. I'll keep waiting. I'll see what else the state has. I will definitely wait and see what the defense has. It certainly seems like they are, even today, that they were laying some foundations for things to come that I don't know what they are. But I sure hope, for everybody's sake, that we start to get more answers as this goes on, because so far, I don't think anybody's getting closure from this. And that's very unfortunate. All right, guys, let's take the time to go ahead and go through some of your comments and questions. We'll start with Lisa Thomas, just a straight super chat. Thank you so much for that. Fashion Chick 24 will be on replay crew, but wanted to give a little something for the hammock or hand warmer fund. Thank you for covering this important case. Funny you mentioned that. I think I mentioned that. Did I mention yesterday that I was thinking about, maybe going and seeing if I could like find at the sporting goods store or something like that, find like a hammock to sleep in, something that's a little bit more comfortable. I was thinking about that. I did actually go pick up a bunch of hand warmers today. We were talking in the line this morning when I first showed up. My guardian angel was there, but I stuck around and chatted with some of the people before I went back to my car. And the weather is predicted to change. It started to cool off today. The wind has come up. We are forecast to start getting cold overnight. And then I believe Friday night, it maybe is supposed to rain. So we are going to start to be really challenged with the conditions out there. I have been very fortunate so far. I think that I have line sitting set up for the next couple of days. These people are freaking troopers to take on this weather just so I can get some sleep. Like, honestly, I'm kind of overwhelmed by it. It's such an awesome thing for people to do. I feel a little bit like I'm cheating, like I should be taking that on. But I did, like I said, I went and got a bunch of hand warmers today. I also got a big golf umbrella. So if things do turn bad, we'll bestow those on the people sitting in line and hopefully keep everybody reasonably comfortable. So thank you very much for that contribution. We may need it more than you know at this point. Underwater Panther, endless thanks for your diligence. Well, my pleasure. It's continues to be a whole adventure, this court process. Post-punk mama, thank you, line sitter. You're the hero today. Yes, line sitter is the real MVP. Thank you again for your dedication, Andrea, and thanks, Mr. Andrea, for supporting. Yes, thank you, Jeff, my original mod. He's a big support. He's been helping me out a lot with some of these things behind the scenes, and obviously a big source of moral support for me. So wouldn't be doing it without him. Jim Green, thank you, Andrea, for your balanced, skillful, and intelligent coverage of this case. My question at this point, I appreciate there is more prosecution testimony. Is there any evidence presented that ties RA to the crime? Not so far. Not so far. We have, at best, the circumstantial evidence, but nobody's identified him as bridge guy. Nobody's identified him as bridge guy. We still, once again, I mentioned yesterday, no in-court ID. It was sort of shocking to me that nobody asked that question. Not so shocking that the parties didn't ask it, because it's a high-risk question for the parties. One of them is getting their case blown up by the answer to that question. But the jury has asked so many questions. I'm really surprised. None of them has asked any of these eyewitnesses. The bridge man, you've described him, the bridge guy, the man you saw. Is it him sitting over there at defense table? Is it Richard Allen? Is he who you saw? Nobody's asked for the in-court ID. Somebody suggested that maybe they did, in fact, ask, and Judge Gohl did not allow it. Obviously, all of the jury questions are not given. We've seen a couple instances so far that I noticed they got more questions than were asked. So not every question is given. If it's not appropriate for whatever reason, it won't be given. The problem, though, is that, and I mean, as a defense lawyer, when I'm in my role as a defense lawyer, I will make all kinds of arguments against in-court identifications. They're the most suggestive, possible thing there is. You know exactly who you're supposed to identify. He's right there. He's sitting at the defense table. Like there's no mystery here. So that's a real problem with the in-court identification and just the reliability of it. But that has never, to my knowledge, I don't know of a jurisdiction where that is a basis to keep it out. They still let it in. You get to argue that to the jury, and then it goes to the weight that they assign to it. So it's not inadmissible as evidence. In-court identifications are routinely admitted. And my perspective on the case at this point, I feel like if Judge Gohl thought that it would inculpate Mr. Allen, she would absolutely let the question be asked. She would absolutely let it be asked. So I guess those are our possibilities. They didn't ask. Nobody's asked. Or they did ask, and Judge Gohl didn't let it in. And if that happens, it's because she thinks the answer is going to be exculpatory. That either no, it's not him, or I can't say for sure, or just something. They're not going to be able to tie it to him, and that is then going to generate reasonable doubt. That, I think, is the concern. So that, I suppose, is possible. But yeah, we didn't get that. So the direct link then is really only going to come, I think, when we get to the confessions and what Mr. Allen said, where he places himself at the bridge in this time frame, and then specifically also puts himself as, passing, having this contact, so to speak, with the three girls who were out there on their walk and who claimed that they saw Bridge Guy. That, I think, is what the connection is going to be. But we do have a lot of evidence still to come. A lot of evidence. I'm very eager for the evidence from the analysts, the DNA, the blood, trace, all of that other stuff, body fluids, all of those things. I really want to know the answers to that information. Dr. Tiny Toff, you would make such a great judge, Andrea. Have you ever considered it? Glad you got to rest. Thank you to the line sitter. What an absolute star. Yeah, it's crossed my mind, but honestly, it's not a position I really aspire to. I've had people suggest it. I swear I'm not like boosting myself or whatever. I'm just giving you perspective. One of the Court of Appeals judges more than one has suggested, you might consider it, because, they go through, they retire, they move on, they do other things and stuff like that. But it's just not really a position that interests me. In Washington, it's a political position. Judges are elected, and that's not my scene. I don't like the political process. I don't like the process of going out and courting the votes. It doesn't suit me. If it was a situation like the federal courts where somebody just gives you the nod and then you have the job like forever, well, okay, that might be kind of cool, but like everybody wants to be a federal judge. Nobody's going to make me a federal judge. I don't even practice in federal court, I mean, not that I couldn't learn, but, so, I mean, yes, I've casually considered it, but I don't think it's something that I really intend to seriously pursue. And frankly, at this point, I don't know how you would do as a judicial candidate with a whole big record of YouTube commentary and Twitter commentary and stuff like that. Does that help me become a judge, or does it hurt me? I don't know. I guess you guys have to be the judge of that. But yeah, I can't say I would never change my mind, but definitely at this point in time, it's not something I have an interest in pursuing. Pantoufle or Pantoufle, I remember this name from last night. Don't know how people have already decided his guilt or innocence when trial has just begun and more to be revealed. Make it make sense. Mob mentality. Yeah, this whole polarization, it happens a lot. It happens in a lot of these cases. It happens very quickly. And I'll give you my sort of theory about how it happens. I see it. Now, obviously, this is through my perspective as a defense lawyer, but I see it as the first thing that happens. Okay, somebody's arrested, they're accused, they're charged, and there's an immediate rush to judgment of guilt. Of course he did it. The lynch mob is out. Let's string him up. Hopefully that doesn't get my stream pulled. There is a certain personality, I feel like, that is judgmental, that is opinionated, that is fixed, that is closed. And so he did it, then we're going to be stuck on that forever. And there's probably similarly people who are like, he didn't do it, and they're fixed. But just what comes to my attention is this fixed opinion of guilt that comes very fast. So then I think the polarization comes because people that question that either like overcompensate, like as a reaction to, you're so sure he's guilty, well, I'm so sure he's innocent. There's some of that aspect to it. But some of it also is just pigeonholing. Some of it, I think, is not real, the polarization. It's just the perspective that if you don't agree with what I say, then you agree with the opposite of my position, and that's simply not the case. I say this because I don't have an opinion on his guilt or innocence at this point, but I know there are people already shoehorning me out there, oh, she thinks he's innocent. They do the same thing with Koberger. She thinks he's innocent. I hold open the possibility that he's innocent, and I talk about the reasons why I'm skeptical of the evidence that would lead me to think, yeah, he could be innocent. But I haven't reached an opinion because we haven't gotten through the trial. So I think a lot of that really is just sort of projection of one's own fixed mindset onto the people that you're talking with. So if you don't agree with me, you're in the opposite camp, and therefore... you either think he's guilty or you think he's innocent. It's just this very, very black and white thinking, black and white worldview. I don't have a black and white worldview. So for me, there's all kinds of room for nuance. That's my thoughts about that phenomenon. Nicholas Farmer with a super chat. Thank you so much for that. Pantoufle again, is RA's daughter there supporting him? If not, why? So I wouldn't recognize her. I don't know who she is. And so I don't know. I don't know if she has been there. I do know his wife has been there. I was originally concerned that his wife was going to be excluded from the courtroom because she's named as a witness. But it doesn't appear that she has been. She's been allowed to attend. So that probably means nobody intends to call her, and they already know that. I don't think the state has her on their witness list. I think it's just the defense, but I'm not 100% sure on that because we don't have the witness list, and I don't, they rattled through those names so fast and voir dire that I was sort of barely able to get a count, but there was no way I was going to be able to track whose name was called. Of course, we had the audios, we could. But so I don't know. I don't know if she's on the state's witness list. If she's on the defense witness list, they can just release her. They can just say, yeah, we don't need her. We can make our case without her, and then she'd be able to attend in the courtroom. But I don't know about the daughter. I don't know. And if she's not there, I don't know what the answer is for why she is not there. It could be that it's too hard for her. It could be that he doesn't want her there. It could be that she doesn't support him. We don't know. I wouldn't want to make assumptions about that. The Iceman, 101-418. If none of the witnesses are willing to link Richard Allen and Bridge Guy as the same person while under oath in front of a jury, shouldn't this case be dismissed at the end of the case in chief? Well, it won't be, because they will rely on circumstantial evidence that he is Bridge Guy. And the main circumstantial evidence is going to be, his, like I said, his own confession, putting him on the bridge in the time frame, running into the girls who say, I saw Bridge Guy. It's not a lot. Is that going to get him to beyond a reasonable doubt? I don't know. It's going to be up to the jury. It's going to depend on, what else comes out in the sort of sum total of things. I mean, let's throw a wrench in it, right? We're going to get all this analysis, all this, all of this swabbing, all this evidence that was taken, the fingernail scrapings that they were able to get from Libby. They didn't get from Abby, but they were able to get from Libby. Maybe there's DNA under those, and maybe it's not his. We don't know whose it is, but it's not his. Is that going to throw a wrench in the situation? Yeah, I think so. But, we don't know. We don't know what's going to come out like that. So it's not necessarily a proof beyond a reasonable doubt case, but it's enough to clear the very, very low hurdle of sufficient evidence to go to the jury. It's just basically, the standard is so permissive. It's just basically look at everything the state's way, look at all of the evidence as if it means what the state is telling you that it means. And if based on that, the state has made a credible argument for guilt, a credible case for guilt, then it's going to be enough to go forward. And you can pretty much tell that just from the opening statement most of the time in a case, unless something really falls apart, a witness, something happens to a witness, or, somebody changes their story or something like that. I mean, these things do happen, and the case can fall apart that way. But otherwise, no, this will be enough. It will be circumstantial, and not particularly strong, based on what I know so far, but it's enough to get past that hurdle. Donna Brack, is it possible for some of these small abrasions left collar front to have been from the tree limbs placed on them? Very good question. Very good question. They didn't indicate there was any debris. They might expect like there would be tiny little pieces of bark or something, or dirt, in the wound, if that had been the case. They didn't indicate that. We only saw all these wounds after they had been washed. We didn't get like the detail of the wound after the tree limb had been removed, but before it had been washed, so that we could see if there was anything like that. Yeah, it seems possible to me. Definitely seems possible to me. I don't know if we'll know, though. They didn't have an explanation for where those small abrasions may have come from. But I think the limbs are a good guess. Janine Harris, can they do a voice comparison between voice of Bridge Guy and Richard Allen? They might be able to. They were able to bring in, the state was able to bring in the guy who did the audio enhancement of the Bridge Guy video. So a comparison is typically going to have to require, it's going to require some technical work. It's going to require some expertise. Somebody's going to have to establish their expertise and their technique. It's going to have to be more than we're all sitting here in the courtroom, listening, and we think it sounds like him. It's going to need to probably be more on a level of like comparing, sound waves and patterns, something a little bit more objective, and not just, yeah, it sounds like him. So if they do have those methods, and there's something that, this court will find scientifically acceptable, because, it's the defense, I'm assuming, that would do this, not the state, then yeah, they should be able to. That hurdle, though, court's got to find it acceptable. And we already got geofence data excluded as being unreliable. So I don't know if they would clear that bar. That could potentially be a tough one. I would have expected a motion in limine, maybe, from the state to suppress or to exclude something like that, if they had it on those kinds of grounds, exclude it for either not being sound science, not being, performed correctly or something like that. But I mean, maybe not. So I suppose it's possible we could get something like that, but I do tend to doubt, if only because we know the defense resources are very limited. And so they, they haven't been able to get what they requested from the court. They had to do with that private fundraising to try to get additional resources to hire experts. Don't really, we don't have a record of what they do with that type of thing. All of that stays concealed, confidential, because it would, reveal too much about the defense's thought process and stuff like that. So leave it at maybe, but I'm going to say probably not. Daylily Wellness. Is there any footage of RA car on camera? We're going to have to find out. They didn't pull any from the Hoosier Harvest store that they've told us about. We haven't really gotten to Richard Allen yet in the investigation, though. We're doing a lot of this background stuff first, and my sense is that's what the structure of the case is going to be. We've gone through the girl's last day, the fact of the murders. Now we're getting into the eyewitnesses and that early kind of part of the investigation. So I'm expecting we'll probably move relatively quickly into the lab analysis stuff. And then from there, we'll move into the future, because I got to presume all this lab stuff, it didn't give them a lead. It didn't give them a suspect. I don't know if that's because there wasn't much there to work with, or I don't know if what there was there, they weren't able to, match it to anybody, to use it to identify anybody. But so, we're going to get through, I would suspect, get through the stuff to the point where the case went cold, and then we'll move forward to Richard Allen, and then we'll really focus on Richard Allen and what we know about him, and the state's theory of how he's involved. So possible, but we haven't seen anything like that yet. Catherine Joy with a super sticker. Thank you so much for that. AKA Radar. Andrea, did I mention your sacrifices mean more than words? Sorry the goal denied your motion. Can we go to the mothership? After all you're doing for us, we got you back, dear lady. Thank you so much. Well, you're very welcome. I certainly was not expecting her to grant it. Let's be real. No, I wasn't expecting her to grant it. I was expecting her to ignore it. But now she's ruled on it. So she's teed it up for it to go to the next level. And that's what I will be evaluating in my very abundant free time that I will hope to have starting this weekend. Well, basically the little bit of free time I have this weekend, I'm going to be looking into that. So Nikki Bobby, thank you, Andrea, for all you do. You're very welcome. Thank you guys for being here with me. Debbie W, Indiana, Andrea, not Idaho. If I have been misspeaking, I do apologize for that. It does happen sometimes. I've noticed as I get older, I am more prone to the malapropisms, where I say the wrong thing in my mind. I know what I'm saying, but just the wrong word comes out of my mouth. And so sometimes I will mix things up like that. Obviously, I've been talking about the Idaho case a lot, and so it just does tend to roll off my tongue talking about Idaho. It's definitely not intentional. So yes, sometimes when I'm talking about the comparisons, I do mean to say Idaho, but obviously when I'm talking about this case, I mean to say Indiana. So did I say Idaho State Police? I might have said Idaho State Police or something like that. I meant Indiana. ISP, yeah. ISP in my mind is still probably going to default Idaho State Police because we've been dealing with ISP in Mr. Koberger's case for so long. So I do apologize for that if I've gotten that wrong. Couch juror, if one knife was used, wouldn't the first victim's blood DNA be mixed in second victim's wounds? Thank you for being there for all of us. Very good chance that it would. Yeah. Yeah, very good chance that it would. I think the possibility, if one knife was used for all of the wounds, yes, you would probably expect that, because at least one of the wounds would have gone directly from one victim to the other victim. And so there would have been some transfer there. Are they necessarily going to catch it? You hope. I mean, you hope. You hope they swabbed it and didn't just wash all that away to inspect the wounds, you know? You would hope that that was done. Let's go back and look at our list of swabs. See if we've got good swabs from the wounds. All right. The stuff we have from the scene, the things they took at the scene. Libby's left wrist, Libby's right wrist, Libby's belly button, above the knee of Libby. Then a bunch of stuff on the ground and the tree. Below Abby's head. Left index finger of Abby, left pinky finger of Abby. Some additional items from the autopsy. Left thigh of Abby, right thigh of Abby, Libby. I'm sorry, I've been saying Abby for both of those. Swab from left thigh of Libby, right thigh of Libby, right breast of Libby, left breast of Libby. The kits, trace fiber. Oof, guys, I'm not seeing any swabs from the wounds. Not seeing any swabs from the wounds. Libby's right wrist. Yeah. They didn't swab them, guys. So we're not going to know. We won't know if there was a mix of blood and whether there was transfer like that from a single weapon. Very unfortunate. Felicia V. I have read that Kelsey deleted info on Libby's phone prior to law enforcement exam. Has this been talked about? In my opinion, if potential evidence were deleted, that is a huge deal. Get an Indiana tenderloin while here. That would be a huge deal. We have not heard anything about that. Possible that would be excluded. This being Judge Gohl, you know, the view that it would be irrelevant because nobody's arguing that Kelsey's the murderer or something like that, or that Kelsey's complicit. I mean, nobody is, I think, arguing that Kelsey's complicit, but doesn't mean it's not relevant. We haven't heard anything about it, so I don't know if that is true, if that is going to come up. But so far that hasn't there hasn't been any indication of that. I did mention last night I am going to miss out on the Indiana tenderloin, unfortunately, because I don't eat beef. I have not eaten. I eat fish, but I don't otherwise eat meat. So I do hear it's quite good. Sure that it's wonderful, but it won't be for me. But thank you for the suggestion. Marcelo, I saw Ron Logan's phone put him standing at or near the crime scene at 10:16 p.m. The judge has forbidden to mention him, right? Don't you think this is a huge appeal issue, or is it because that he is dead? They can't show that. No, I don't think it's because he's dead. Certainly the third-party culprit stuff was all excluded just because she said there's not enough evidence to meet the standard for Indiana. Indiana requires proof of a direct link between the other suspect and the crime. Well, to me, being at or near the crime scene is a pretty direct link. 10:16, it's when the girls are missing. We don't actually know when the time of death is. Yeah, I mean, the third-party culprit stuff has been a big issue for me from the appealability standpoint. The whole other issue here with the phone and the phone data, this is going to be stuff I would think. I mean, maybe, I don't know if they extracted Ron Logan's phone or if this was part of the geofence data. Since I didn't get to attend those hearings, those evidentiary hearings that they held back in July and August, I really don't know a lot of the details of some of what got litigated in there. They took a lot of evidence, and it's unfortunate. We don't have transcripts. We don't have recordings. There's no way to really go back and revisit that. So I don't know if that's part of the metadata or the geofence data that also got excluded, or if this is something separate, his own phone that they examined. Either way, you know, third party culprit is gonna keep him out. So I am trying to think back. I feel like I do feel like they examined his phone. I got to go back and look at some of that detail because I just don't remember off the top of my head. I'm gonna have to check out the All Eyes on Delphi is like there's lots of good sources for information. Sleuthy Goosey is always like one of my top go-tos. She's got great stuff on this. What I like about the All Eyes on Delphi is they have a timeline. They've like organized things in the timeline. And then sourced it back to the document that information came from. So it's easy to go check the timeline and see, like, you know, if there's an entry where Ron Logan's phone was extracted. I just don't remember off the top of my head, but I am kind of feeling like maybe it was. 2 blue crayons with a super sticker. Thanks so much for that. Kathleen Kaselke, Sweet Pea with a super sticker. Thank you so much, Sweet Pea. That's wonderful. Theory neutral. Goal's judgment on your motion was lame. 2, lots of substance today. Thank you. 3, did any witness say bridge guy looked like RA? 4, was the cause of death bleeding? 5, did the girls walk that path often? I agree. The judgment was kind of lame. I sort of knew what was going to happen with that argument about the audios because I had already been alerted that there is an interpretation of this rule that says that because the criminal defense attorneys, the criminal attorneys are allowed to request copies of the audio, that it means the rest of us can't. So I was sort of predicting that that's where she was going to go. It's the rest of it that's lame. Oh, she's just complaining about the trial process. Well, let's be clear. I certainly am complaining about the trial process, but that's not just what I'm complaining about. I'm complaining about the important constitutional issue of public access and the fact that there is now a group of the elect in the courtroom that have been granted this extraordinary access while the rest of us are being denied. And it's not appropriate. It's not legally substantiated. Once the door has been opened and the process has been established for those exhibits to be shared publicly, we should all get the opportunity to share in that. So yes, it's a very lame response, and we will be dealing with it accordingly. I agree, lots of substance today. None of the witnesses has said bridge guy looked like Richard Allen. There's been no comparison whatsoever. Nothing, I mean, even if we came up short of an in-court ID, not even yeah, he might have looked sort of like this guy. Nothing at all. We did not actually get a cause of death. They didn't elicit the cause of death from the forensic pathologist, which I thought was maybe a little bit odd, but it did seem to also kind of be self-explanatory because these were the only wounds that they had. The exact, was it exsanguination? I assume it was, but I don't know, that maybe there were other contributing factors or something like that, just given the conditions or something. They didn't say. We're in a murder trial. We didn't get the cause of death. The girls, I believe, yes, the evidence was that Libby particularly would be down there at the bridge. She liked to be down there at the bridge, in part because Kelsey liked to be down there at the bridge because Kelsey likes photography. She likes to take pictures. It is an extremely scenic area. Very nice place to be out taking beautiful like landscape type photographs. So Libby for sure would be down there at the trail. Abby, we have less information about. We know that she had been across the bridge, I believe, before, but I don't think to the extent that Libby had been down there. Dr. Von Decay is a new channel member. Thank you for joining us. Welcome. Sweet and Salty with a contribution for pens. I am going to have to go and get more pens. My pen box is running running dry. I'm going to take a whole handful of them tomorrow because now I'm paranoid. I have 5 pens left in my box, so I'm going to take 3 pens. I have to give one to Lawyer Lee. I still have her pen from yesterday. I'm going to take 2 with me. I'm going to leave 1 here at home in my little office space here. And then that leaves me with 2 extra pens that I'm going to leave in my car so that if, worst case scenario, I can run out at lunch or break or whatever and grab a pen. And then I will go buy another box. So I am a little paranoid now about losing the pens. Rusty with an I. Once again, your coverage is so detailed and thorough. Thank you for your time and sacrifice to provide us with the happenings of the trial. You are very, very welcome. Kathleen Koselski, Sweet Pea with a, oh my goodness, enormous contribution to the Pen Fund. Thank you so much. Love Kitty questions. Yeah. That's going to buy a lot of pens. I really appreciate that. I will never run out of pens. Uncivil Law. Welcome, Kurt. Good to see you with a Lamy fountain pen, Noodler, bulletproof ink. I like my pen. I like these pens. My Uniball Vision Elite pen. It is a ballpoint pen, but it's just it's a very nice ink. It just flows. It writes so well. I love this pen. I've been telling people about how my husband and I, when we had our law office together, we were both kind of pen snobs, but we had different choices of pen that we were snobby about. So for me, it was always the Uniball Vision Elite. For him, it was, I think it was the gel. I forget who made his gel pen. But anyway, so it would cause controversy in the office if one of my pens ever showed up in Jeff's office, or if Jeff's pens ever showed up in mine. Like, you don't even like my pen. Shredder S07 at Andrea Burkhart, Raid from Potentially Criminal. Been watching your coverage anyway. Great work, and thanks for showing up in person. Well, thank you for coming by. Welcome to everybody from Potentially Criminal. That is awesome. It is a whole thing seeing this unfold in person. It's a very, very different experience, and especially just given how this is all we got. This is all we got. This is all we have to know about the trial. And like, so it's really like emphasizing to me, I'm realizing how much I wish I had been able to do this for the pretrial stuff, just because I'm at that point. Like, even just now, I'm talking about the evidentiary hearing from back in July and August. So much information came out. No idea what it was. No idea what it was because, we weren't able to be there. I've seen some news stuff, but I've already seen from this context how difficult it is to rely on what the news media is reporting. They're often getting details wrong, and it's just not particularly detailed. They pick like the high point of the day, and that's really what they report. They don't report all of these details, and the details are what are so significant in this particular case. So, woulda, coulda, shoulda. I had other key things going on, and so it wasn't going to be possible, but it is unfortunate. I wish I had been able to do that before. Pixelate me. What a great username. Thank you. I appreciate your support. Tina with the contribution. Thank you so much, Tina. Emmy, thanks, Andrea, and thanks to the line sitters. Yes, the line sitters, the real MVPs. Thank you so much. Blakesley K with a super sticker. Really appreciate that. Roger V. Kent, an extra cup of joe. I'm going to need more than a couple as the weeks go on. But, hey, we're Lawyer Lee pointed out to me we can't technically call today hump day because we've got that half day on Saturday. So we're not, although it is only a half day, so by getting through the full day today, we are technically over the hump. So we're practically already almost one whole week down. And then there's only like 4 more to go, 3 more to go, 4 more to go. We'll get through it. It'll be fine. Indy Cindy with a super sticker. Appreciate that. Thank you so much. Lisa Thomas with a contribution. Thank you so much for your support. Heather Brown, Andrea, thank you for all you're doing. You are so welcome. Really appreciate all of your support, guys. Poe Honesty. I don't trust Gull. I predict a mistrial if she smells an acquittal coming or a directed verdict after the confessions. Thanks for your work. I don't think so, and I'll tell you why. So first off, she cannot give a directed verdict for the state. That is not allowed. It's not a thing in criminal court to do that. The defense can ask for a directed verdict because they're basically saying, as a matter of law, the state has not met its burden of proof. But she cannot find, as a matter of law, that they have. That is exclusively a question for the jury. So there will not be a directed verdict. I do not think she will give a mistrial because mistrials are extremely risky. The reason why is because jeopardy has now attached to this case because a jury has been sworn in. And that means there's pretty limited circumstances when they can get a do-over. A mistrial requires a finding of manifest necessity. So it has to be essentially the only thing that is possible in the circumstances. It requires something pretty egregious. She's not going to be able to just pull some little thing and say, I don't like how this is being done, so we're going to do it over. You don't get a second jury when this one is sworn. If there is no manifest necessity, he is entitled to a verdict from this jury. This is the one that he picked. So that would be opening up a double jeopardy problem. They would not potentially be able to retry him. It's very, very risky to do that without very good cause to declare a mistrial. So I do have faith that Judge Gohl understands at least that much. Laura, could the defense be talking about interaction between the girls and RA phones? And I thought in opening they mentioned his phone leaving. Also, RA gave them phone ID number. Okay, I didn't know that. That I just assumed they subpoenaed it from his carrier or something like that. But if he gave it to him, like, wow, he's being very, like, how did he even know? I don't think I would even know. I would have to go hunt for it and then give it to him. Like, that's being really super cooperative with the investigation. You know, they didn't ask the witness to clarify that. When he was talking about no contact, he did use the word communications. He was talking about they did not communicate with each other. I suppose it's possible he meant like the phones didn't commute, but it's not an issue of phone communication. It's really about the phones being in the same place at the same time. I don't think that can be interpreted that way. And you know, the defense didn't follow up, like if that was the case, they didn't follow up to clarify that. So I don't think that's probably what it is. I think that's a good thought. But yeah, I don't think that's what he was talking about. I don't remember them mentioning his phone leaving and opening because I don't think they're allowed to do that. What I remember them mentioning was his car. They're talking about his car leaving, and I'm not quite sure yet how they're going to establish this. We had the little piece that we already know about with Betsy Blair that he definitely told us about in opening, because they're trying to say that Richard Allen parked at the CPS lot, went and rocked the trails, committed the murders, walked back down where Sarah Carbaugh saw him on the road, got in his car and left. Betsy Blair was there during the time frame when Richard Allen would have had his car parked at that lot, and she identifies a car parked there, but it's a car that is nothing like Mr. Allen's car. It's the one that looks just like her dad's old car, the Mercury Comet. So that, I think, is maybe what you're remembering from the defense opening. I don't know if they have other evidence of his car's location. It would be great if they had a security camera somewhere. Like if they had that, that's pretty exculpatory. You know, put his car somewhere else. It's not definitive unless they got his face in it, behind the wheel. Maybe he ran a red light and they got a stoplight camera. Those things happen. But at the same time, you would expect the state would have found something like that, and that would have become an issue at some point in the investigation, either or some point, in the case, either with Franks or with Brady, a Brady motion or something like that. Like that's pretty significant. That would be pretty significant evidence. So I think it's the car that we are focused on with that. Carazola X, sucks that people are distracted by the funny suitcase lady and not paying attention to this case. It's so much more important, worrying. I mean, the suitcase lady is on TV, so it's easy. It's an easy one to watch and focus on. I totally understand that. It is not easy being here and getting this information. And I know, just speaking from personal experience, it's so difficult to cover the trials that aren't televised because it's so hard to get the good information. That's literally why I'm here, because I knew when it wasn't being televised and how important it is. There wasn't going to be any other way to be able to talk about this case. So I had to be here because there's not going to be another source if we're not getting the audios and so forth. So I really do understand. But I agree from my standpoint, the suitcase lady was not particularly interesting. Although I will say, from what I've seen, I've just seen little bits and pieces about how it seems to be going. It does seem to be going differently than I had expected. I had expected it to be Daryl Brooks in a dress. That's what I expected. Doesn't seem like it's gone that way. Her having a lawyer, probably changes that scenario quite a bit. But I've also heard at least some folks seem to say, she testified and thought she did pretty well. Not a universal sentiment, of course, by any means, but I would say prior to her taking the stand, I think pretty much everybody would have predicted it would be a train wreck. It would just be a disaster, and it doesn't sound like it was. So in that sense, that's kind of interesting. That is a different development. Harry Leachman, appreciate how nuanced your coverage is. Don't always agree with your conclusions, but I respect the hell out of your ethics. Keep doing what you're doing. Well, thank you. I definitely don't expect everybody to agree with my conclusions. And they're just my thought process. That's part of why I love having the chat, having the comments, having just other people's thoughts. People have great ideas in here, that some things that I've never thought of, some things that I've never thought of. Boy, I'm trying to remember now. Oh yeah, the suggestion today about the connecting the lines on Abby on her chin. Maybe that has something to do with this handkerchief and realizing, this handkerchief that was recovered. We don't know where it came from. We don't have a provenance for it. It's a mystery hanky. Could those things be connected? This was like sort of a group brainstorm, a bunch of us talking while the case is in recess. So I'm just one person with my own ideas, but I think everybody having their own ideas and sharing them in a respectful way, that's what helps us get closer to the truth. Because yeah, people have all kinds of good theories and good ideas about how things that work, and yes, makes me shift my perspective, quite a bit of the time. So don't by any means feel like you need to agree with me, and if you disagree, I would love to hear why. That's some of my favorite conversation. I'm a lawyer, disagreement is second nature to me, so I don't take it personally at all. I just my rule is like, don't attack people. Don't make stuff personal. Disagreements about stuff like this shouldn't be personal. It's about ideas. It's about information. It's about getting to the truth. So it's a constructive process when we do it right. Catherine Joy, we so appreciate all you do. Well, I appreciate all of you being here and all of your support. It really has been overwhelming. Truth Seeker, what time are you getting there? I came up with an idea and you meet me with Julie Friday. Thank you for everything, Andrea. I have an idea about drinks, snacks. Tomorrow I'm supposed to get there at 7. That's when the line sitters will be done. So I will be there at 7 tomorrow morning. Everything else kind of up in the air, so I'm playing a little bit of wait and see. It will depend, but I would love to see you if you're there. Show up. That would be fantastic. Sarita Banana, if the prosecution is hoping the jury finds R.A. guilty based on post-arrest confessions, then what do you think the jury will consider to be factual as the basis for the arrest? The jury isn't going to be asked to consider the factual basis for the arrest. It's not within their purview. If I'm the state and I'm addressing this issue, I'm saying, okay, maybe you don't think the evidence was strong. Maybe you think it was a guess. Well, the confessions show they guessed right. That's going to be my response to it. I definitely don't think that, the PC is strong. Not a lot with the PC. If they didn't have those confessions, this case is so much harder. This case is a lot harder without those confessions, if only because, well, we do still have his original statement to the police where he put himself on the bridge and he put himself meeting the girls. That's really where things went south for him. That very initial cooperation. So if he is innocent, it's really a cautionary, it's unfortunate that it has to be a cautionary tale about being a good Samaritan if he didn't do it. If he did do it, that wasn't a good call, bottom line. Truth Seeker, I'm willing to bring snacks and drinks at lunchtime and coffee and donuts early morning for a selected few. That is, sorry, trolls. Lol, much love. There are a few trolls around. Not going to lie about that. Thank you. It's very, very generous. We have, I don't know if you heard, we have now been allowed to bring food into the courthouse. Food and drink, we can bring it into the courthouse. We simply can't eat it in the courtroom. So what that's looking like now is I'm able to bring a little lunch. We're able to bring little snacks. And during the breaks, we can go out into the hall and we can eat them and we can have our drinks. So we are no longer starving. We're not on the Delphi starvation diet anymore. Guys, I will tell you, I noticed it's having an effect. I noticed today, I said something to Julie about it because, I was going down the stairs. It was when I went to get my pen out from my car. My pants are falling down. Like this is like been very extreme, very fast, but we are on a correction route now. So I will not continue to starve. I will be able to get food. But I would still love to meet you if you want to come by. Maybe, just connect. And at some point, all these people here in town, I would love a chance for us to get together, especially the line sitters, certainly I would love for us to be able to get coffee, get a beer. I mean, anything, I'm so grateful for everybody's support. And it's really been awesome to meet everybody that is a fan of what I'm doing here. It never ceases to amaze me that so many people are interested in what I have to say. To me, I'm just a person with some thoughts that I say into a mic, and it kind of blows my mind all the time that so many of you are interested in following it. Theory Neutral, would you please post an image of stick patterns? Yes, I did my little sketch of their sketch. The things that have been controversial about the stick patterns have been the sticks over the puddle of blood and exactly what that looked like. And then also whether there were sticks. People are asking about sticks over Abby's head because that relates back to the statement that Elvis Fields had made about putting the horns on the girl. There are no sticks over her head. I can tell you that from the sketch, or just from memory. My sketch, I was getting the general gist. I would not want to like represent it as being a super accurate diagram. I'm a terrible artist, guys. Like I honestly, I can barely draw a stick figure and it shows. So I did do my best, but like it's not, do not rely on it for detail or anything like that. I will share it for the general gist. But I say that with some hesitation for those very reasons. Now, if I could see the exhibits and draw it again, make sure, like, double check my drawing, I'd do that. But apparently I'm just complaining about the trial process. Amanda Colbert, anybody know the name of Kelsey's 2017 boyfriend? I don't. She didn't say at trial. So I don't know who that is. Catastrophe. We bought the transcripts for thousands. Videos to listen to us all reading as the players, including Goosey and All Eyes on Criminality 187. T has helped crush the transcripts game. Beyond grateful for you. Are you talking about the evidentiary hearings? If you are, I would love to hunt those down. And oh man, maybe I would have time this weekend to get caught up on that. I might have to wait, kick it to the following weekend. But yes, I am very interested in seeing the transcripts of those hearings. That is music to my ears. I will look out for that. Precocent, pen snobs, my kind of people. Pilot 1mm. I prefer like not a super bold point, but close to bold. I'm not really a fine point, not really a fine point girl. I like my ink to stand out. I like to be liberal with my ink, not have challenges reading it. We all have our own matter of taste. That's something that we can disagree about respectfully. I think was it a Pilot gel? Might have been Jeff's pen. It might have been a Pilot pen. I just can't remember off the top of my head. Kate E., you rock. Civil procedure rule cited in Judge Cole's ruling on your motion. Wow. Yeah, right. I mean, I did notice it's the trial procedure rules. It's not necessarily applicable to the criminal rules. So yeah, it does become a little bit of a question of what exactly applies in this situation, and if there is a conflict between the rules, which one is going to prevail. But yes, I agree with you. The criminal rule does not say only the attorneys get the audio, and so then I would think we default to the rules on the public access, where it's just flat out public records. Anything is a court record. This qualifies as a court record. And if it's a court record, public access means I have the right to inspect and copy it. I get both, not just one. I get them both. So maybe we will need to just explore ways to see what a higher court would think of that decision. Felicia V. at Andrea Burkhart, to clarify, I don't think Kelsey complicit. Understood. If she deleted, it would be embarrassing stuff. Maybe Libby sent compromising photos while catfished. Delete to protect LG before new relevant. Yeah, I mean, I can see something like this too with the whole Anthony Schatz angle. Like we know, I'm pretty sure we know that there was communication between them and that he was a catfishing guy and that was his whole thing, and he's gone down for child exploitation. So, yeah, I mean, I could definitely see something like that. And in that case, that would also be why I could see it potentially being irrelevant. If it's not a situation like, oh, Kelsey's complicit, which, like I said, you're not saying, I'm not saying, I don't think anybody's saying, then it isn't necessarily relevant to the murder trial. It may be relevant just for purposes of establishing why certain information maybe isn't available if some of the deleted stuff is relevant. So like if she deleted that photo, I don't know why she would delete that one because it's not incriminating. Uh, Maybe it's just by accident or something. I don't know. But I could see that being a reason why, it wouldn't be allowed to be mentioned because it just, it's embarrassing and it doesn't have anything to do with the reason for the murder or anything like that. So yes, very good point. Thank you for clarifying that. I agree. Nobody is saying that Kelsey is complicit. Tammy Martin, have you read the first Frank's memo? Judge Gull hasn't even read it. It's very telling. It will blow your mind. Oh yeah, I read the first Frank's memo. I've read all the Frank's memos. The Frank's memos are what dragged me back like into the case with greater attention. I've kind of said before, it was on my radar. I remember when the girls, I remember when they were killed. I remember that. Completely fell off my radar, paid no attention to it. I remember when Richard Allen was arrested because of the sealing. I remember the sealing, the probable cause affidavit not being public. I remember that happening. I remember thinking, that's weird. I guess Indiana has some weird rules about what's public and what isn't. Didn't really think anything further about that. Frank's memo came out, read that. Wow. You do not read that memo every day. You do not read that memo every day. And I understand the people that, I understand why they argue that this is, it's like a PR sort of move. It's like for attention or just something by the defense. Because it does very much get your attention. Yeah, it's a real attention grabber. I think the problem with that analysis, of course, is that the defense didn't make it up. They got it from the law enforcement. It was because law enforcement was investigating all of this stuff that defense, ultimately got it in discovery and, had figured out some of it independently themselves in their own investigation. I think just by looking at the connections and stuff, but looking at the tips. I mean, some of this information had come into the police through the tips, and not necessarily what got them to look at it, but certainly it's like another source. The stuff that was posted on Facebook that got tipped to them. Yeah, if I'm the defense and I see that photo that got posted, that Brad Holder posted, the one of the fake crime scene, yeah, I'm following up on that. It's uncanny and it's creepy and it's weird. But yeah, bottom line, they got most of it from the law enforcement. So this isn't something that they just blew up, for purposes of creating a big public ruckus and a PR machine. It was handed to them in the course of discovery. So it is definitely quite a piece of reading. If anybody hasn't read that, consider it. We're not hearing anything about that in this trial because all of it has been excluded. The crypto tax lawyer. 1, do the OA. What is the OA? Is that the oral argument? Do the OA. 2, will you and Jeff get to see each other on weekends? No, just remotely like this. I am here for the long haul at this point. I went back last weekend for the fight. I'm very glad that I did. It was a great weekend, but it also I lost a lot of time. It really set me back, like starting the week on short sleep because I didn't get into Indy until midnight. And then I got back, I had to come back here. I was working on that motion, had to get it finished, had to figure out how to file it, do all that, and then still make it over to the courthouse. So that's why I was I was 36 hours without sleep when I did my stream on Monday. I can't do that consistently. So I don't expect to be going back to see Jeff on the weekends, but we will chat. We will communicate. We have a great relationship like that. So, distance, when you have a real connection, distance doesn't matter. 3, my husband is also an attorney. We could never work together. I've had so many people say that, like, oh my God, I can never work with my spouse. We worked together for just about 10 years. The thing about being a lawyer, with both of us being lawyers, working in an office together, we did work in pretty distinct practice areas for most of the time. And so even though you work together, you still almost never see each other because he's in a meeting, I'm going to court, he's, going to a lunch, I am going to the jail. Like, it's just, your paths don't cross. You're both running your independent cases. There were a few cases that we collaborated on and worked on as a team, but for the most part, we did work independently. So honestly, we really didn't see each other at work any more than, I think couples that don't work together would tend to see each other during the day. We did get to go out to lunch a lot together. That was nice though. I mean, that's fun. That's a good part of the day. So, OA, original action. Yes, original action. That's what I'm going to be evaluating. I mean, it seems like the obvious pathway. I know the standard is potentially difficult to meet. But yeah, I'm gonna be looking at that process, looking at that rabbit hole, and that's what I will be exploring for sure. So yes, thank you. The original action. 4, you and Lawyer Lee need to do a collab. I agree. I would love to do a collab with her. I think that would be fantastic. Maybe I'll suggest it. I know she did recap over the weekend. I haven't really planned on doing a recap over the weekend on my own channel. I'm going to be going on Sunday afternoon. I'm going to go on Grizzly True Crime. I'm going to go on with her to give like the weekly recap. So I already have that kind of lined up. But she does a weekly recap on her channel, or at least she did last week. So maybe I'll suggest if she wants, I'm happy to go on. I would love to do a collab. She has been great to have at this trial. Just, not just another person there in the trenches. The trenches really do build that brotherhood, sisterhood, as it may be. But just, having another person, having another lawyer's mind, the ideas to bounce off each other, all of that stuff has really been, I've really enjoyed it. I've appreciated having her here. BLT became a YouTube member. Thank you for joining us and welcome. PDF photography. Did anyone ask if the ringtone volume was on? Wouldn't someone have heard the phone ringing when family looking for them? See? This is why I love the group mind. I didn't even think of that. No, nobody asked. Nobody asked about the ringtone volume. Nobody asked about that. That's such a great observation. It must, yeah. Did it get put on silent? You would hear it so far in that woods, the way the sound carries. You would hear that for at least quarter mile, maybe half mile. I mean, you are going to hear everything in there. I don't know if it's part of just because the creek is in a depression and how that works with the sound or something. But, yeah, you would hear the ringer if it was on. Such a good observation. Tilly T with a super sticker. Thank you so much for that, Tilly. Really appreciate your support. BLT, my goodness. Thanks for what you are doing. It's incredibly important for us to be able to get multiple viewpoints from different media that have different motives and obligations. I could not agree more. I think it's so important to hear the different perspectives. Mine is just mine. I am not the authority. I am not definitive. Take it for what it's worth. I like hearing from other people too. I think we all get more intelligent that way. The more we can test our ideas off of each other. Here's 2 Starbucks coffees after YouTube and taxes. Lol, you're a hero, dude. Well, thank you. Boy, that's black-pilled, isn't it? And yet not entirely wrong. Thank you. I really do appreciate that. Ashley. Asli. Apple has Wi-Fi calling. iMessage can be with Wi-Fi only. No tower connection would mean no SMS though. Airplane mode possible if on Wi-Fi somehow. That's interesting. I did not know about Wi-Fi only calling. So yeah, if she had Wi-Fi enabled, I suppose that could be possible. Suppose it could be. She was connected to a Wi-Fi network down in there. I don't recall. I mean, I didn't check when I was down there. I had 5G. You know, I was getting 5G service. I didn't check to see if there was any Wi-Fi connections, any open connections or anything like that. Could be possible. Akira, I would expect Bridge Guy's pants to be wet going through the water. No witness has stated this, or did I miss this? No, it's true. She did not say that his pants were wet. And the other thing, this is again a good point. You've given me an idea because Sarah Carbaugh is the one who saw him after the fact. Described described the pants as bloody, basically from the knee down, and she was describing it as blood droplets, like it looked like a spray. I suppose, I mean, either way, if the pants were wet first and then got blood droplets on them, or if it had gotten the blood on it and then gotten in the water, those blood, it's going to run, right? It's getting late, guys. One of those properties of water, I don't think it's the surface tension that would do that. But it would, the blood, if it's, especially if it's still, fresh, still wet, it would seep. It would seep into that wet area. So it would not be like a distinct droplet. You would think it would look more like smears or something like that. So she's the only one that has claimed to see him after the fact. She did not say anything about the pants being wet. Her description of the pants, especially because she's describing him as so covered in mud. So covered in mud. That's not consistent with being wet. Could he have gotten wet and then, I don't know, scooted down one of the creek banks or something, like rolled down, I don't know, got real dirty? Maybe. It's just that it doesn't explain the pattern that she's described. If she's accurate in her description, that it was blood on his pants up to about the knees, and above that it was muddy. It's a strange pattern anyway to kind of be describing, but if you're sliding around in the mud, climbing out of a hole or something like that, you'd think you're going to have mud all over the bottom of your pants, way more than you're going to have on the top of your pants. So it's just a little bit of an odd description altogether. But yeah, I agree. Nobody said his pants were wet. Catherine Joy with a super sticker. Really appreciate that. Appreciate all your guys' support. Boy, this has been a bit of a long one. So maybe a little bit longer than I thought we were going to go. But I really do appreciate all your comments, all of your support, all of your stickers, all of your questions, everything. It's just been a great group experience already. We still have a lot of trial to go, a lot of information to get. You've given me so many good ideas and just things to think about. And now, at least the next couple nights, I'm going to be able to get some sleep. Hopefully that's going to help the synapses fire back up at their normal speeds again, be able to retain a little bit more and process a little bit better. I know that losing sleep is very unhealthy. I've talked about how, it doesn't really bother me. Like I'm not feeling bad or anything like that. And it's true. I mean, I feel like I have a pretty good perspective towards discomfort. Boxing has taught me a lot about that. But I do recognize that my subjective feelings about it aside, losing sleep is extremely unhealthy. Was it Theory Neutral? Was it you that asked for my book my book recommendations at some point. Maybe it was Jeffrey Thornton. Somebody did. I remember a comment. Somebody asked me for my book recommendations because the very first one I gave was Cadillac Desert. Just sort of randomly, it was on my mind. But another interesting book recommendation that I really enjoyed. I like nonfiction. I can give you some fiction ones sometimes too. I like fiction too, but I really do enjoy nonfiction. Why We Sleep. Why We Sleep. Fascinating. Absolutely fascinating read. Like, we don't know that much about sleep. Like, it doesn't make sense in so many ways, like how we have this whole shut off. It's so much like a computer, right? Like, we need to shut off and load our updates and things like that. Yet we're, a biological creature. Really, really fascinating. A lot of just information about what we know. And yes, the effects of sleep deprivation and stuff like that does not take much at all before you start, losing your cognitive abilities. So I am very aware of that. And hopefully that hasn't been too much of an issue, notwithstanding the Judge Bevs and the Idaho Indianas. I blame that on the sleep, but I do tend to the malapropisms. So anyway, if you're interested in that, it really is a fascinating book. One of the things I just thought was really interesting too was it just talked about how all kinds of different, like, everybody sleeps, right? All animals sleep, even like little microbes. They seem to sleep. Like, I'm sure their experience of sleep is not like ours because we don't we don't have the same nervous system. But all animals sleep. We sleep for different lengths. We have like different sleep patterns. I just find all that kind of stuff really interesting. So, great book if you're interested in it. Ms. Torian gifted an Andrea Burkhart membership. Thank you so much, and thank you on behalf of the person who got that membership. I'm sure they will be very appreciative. I'm going to go catch up on my sleep, guys. Chug the rest of my water, get dehydrated, and look forward to waking up at the glorious, glorious late hour of like 5:30. It feels so luxurious. I'm really going to get to sleep in. It's going to be fantastic. So, just once again, big old shout out to the lane sitters, absolute guardian angels. I was so overwhelmed to get there and just see that this wonderful person and taking it upon herself to volunteer to do that, and just took the initiative to show up and do it, and is helping to organize it for future days. I'm so grateful. Really is going to help a lot. Take a big load off. So. So grateful. Shout out to you guys. Shout out to Lawyer Lee. Thank you for saving me with this pen so that I could get those jury questions without too much more. I was even shaking my pen to get those last little bits of ink out. I don't think I was going to make it, especially given how many they had about that forensic extraction. Thank you as well to all of you guys. Shout out to all of you. Shout out to all of you that care about this case, that care about justice, that care about truth, seeing that the right thing is done, that care about transparency, and recognize that these are our courts. These courts operate for us. They operate in our name. We are responsible for them, and we bear some responsibility for what goes on in them. So that's why it is so important for us to monitor them, to be aware of the processes, and keep track of what is happening, so that when it's wrong, we know and we can do something about it. So thank you all so much for joining me on that mission. It means a lot to me. It's great to have an army for things that matter. So looking forward to day 9 tomorrow, guys. Looking forward to seeing it with a little bit more sleep, and looking forward to seeing you all again tomorrow night for the recap once we wrap up day 9. Very interested to see what we have on tap tomorrow. So thanks again for joining me. I will look forward to seeing you soon.